Brother.
Item 1.
Item 41, my lord. 41, you want time?
My lord, may I take?
You are for petition.
My lord, I am for the opposition party.
I am from the opposition.
You are agreeable.
In another case, I am the petitioner. In second case, I am the
Get the request of.
yeah. That's my great pleasure.
Item 1, may please, Lords. In this civil revision, my Lord, this is a matter arising out of an order passed by the
Division is under 115. CRP is under
Not
which
so.
section of which law?
Lord, CPC under CPC 115.
Under 15.
And the order impugn is the rejection of my
Make use of the mic.
Lord,
Voice should be, your justice is directly proportional to the decibel level.
Lords, my Lord, in this civil revision, my Lord, my challenge is the order passed by the learned civil judge senior division in rejecting my application filed under order 7 rule 11 for rejection
For dismissal.
of plaint.
For rejection of plaint.
Plaint. It is rejected.
11D or
11A, my Lord.
11A?
Yes. Because there is no such disclosure of cause of action. This is my specific case before the learned trial court. The learned trial court, Lord, I was allowed, the other side was allowed sufficient time. He did not file any objection to my 711 application. However, the same application was rejected on the ground that it is a matter of fact and law, and it will be dealt at the time of trial, Lord.
Okay, let us see.
Lord, the impugn order?
No, pleadings. Show
Yes.
the pleadings. Supreme Court said in 1951 under the old 1908 Act,
Lord,
where the case is under, it was 711 something other earlier, whether cause of action has arisen or not is a mixed question of. If that is so, the trial has to take place.
Yes, Lord.
How he has coined the cause of action clause in the pleadings? Plain?
Yes. Lord, the case, the
Read. How it reads.
Lord, in part 11, he says, Lord,
Suit is for?
it is for defamation suit, my Lord, claiming damages for the emails exchanged between parties, my Lord. There is no third person involved.
No, we do not know. Whether third party is involved or not, whether somebody hacked your email, whether somebody peeped into,
Well,
suppose
But
the
I'll-
person is reading
Yes.
the email, the wife comes from behind and peeps into what my husband is doing.
yes, my Lord. My Lord,
So wife is also a third party. So there can be Cassidy versus Daily Mirror. Therefore, it's a question of.
I bow down, my Lord, but Lord, may kindly allow.
Read.
Yes, my Lord. The petitioner,
Read.
para 11, he says, my Lord, that the defendant maliciously, unlawfully made false and imaginary allegations against the plaintiff Messrs. Imbue traders. Such allegations are derogatory and have badly affected the reputation, name and fame of the plaintiff. The defendant humiliates the plaintiff and also harassed her mentally by giving threatening for which the plaintiff is in deep shock and suffering from mental agony, which cannot be compensated by way of cost, and the defendant repeatedly harassed the plaintiff. Para 12, Lord, that the defendant has annoyed the plaintiff and lowered down the reputation and estimation of the plaintiff. Further, the false propaganda made by the defendant as stated above, without any doubt, are its malicious attempts to send a wrong message to all as well as to tarnish the image.
What about the allegation?
The allegation is that, Lord, the plaintiff, I initially sent the legal notice to the plaintiff saying that your GST number has been used by some of your staff, and there is an outstanding of rupees 12 lakhs. Please pay it. Then she responded to another legal notice, my Lord, saying that I don't know this person and therefore you cannot demand that amount from me. Thereafter, my Lord, I again requested her to see this, your GST number has been used in that transaction, so please pay it back. Then she sent me a legal notice saying that she will go for filing a damage suit because there has been loss of reputation in the society because I have sent her those legal notice. Now,
Where is your legal notice?
yes, sir. So the first legal notice is at page 20, annex 2.
What is defamatory in that?
My Lord, my case is that there is no such defamatory statement.
But that's all. That's always the defendant will say that.
Yes, sir. So therefore, my Lord, I will request your Lordship to kindly see page 21, para 5.
issue emergent notice, interim order of stay of suit proceedings till next date of case.
Great.
Next.
Item 2.
May please, your lordship.
Is it not 7, 1A and 1D appealable order? Go to order 43, rule 1.
No, it is not.
Not appealable. Okay.
It is revisable because your lordship see 115. If it would be allowed,
It should have written in the
Terminated the suit.
You are right. Both is right. Yes.
May please, your lordship. Well, here the petitioner seek a direction to the principal of the college to join the employees provident fund from the date of eligible institution to join the fund, my lord. My lord, I have also approached the principal as well as the employees provident fund commissioner under annexure 6, my lord. Mr.
7.
My lords. So,
Ah.
so our institution, my lord, as per the Employees Provident Funds Act, my lord,
Take notice.
my lord, I will take notice, my lord.
Emergent notice. Mr. Lenka is requesting to give here. Mr. Lenka is requesting to also.
1, 2, 3.
1, 2, 3. Emergent notice to the rest.
My lords.
Okay.
Item 3.
Can I let's not a same case.
Ah, what is this, brother?
Notice. I have given the copy.
Why
Similar matters.
similar matters?
Same matters. And
Yes. Same.
all are same.
All same. Okay.
Item 4.
May I please, your lordship? May I please, your lordship? In this case, your lordship, the petitioner is a poor SC girl. In 2019, she got admitted to Maharshi Women College, which is affiliated to Ramadevi University. In 2021, her mother suffered a spine injury, following which the petitioner started, continuing with the studies, she started to do part-time jobs. In 2022, your lordship, after completion of her course,
Why they say you can't appear for the pending 5 papers?
lordship,
Why they are saying you cannot be permitted to take up the back papers examination?
exactly, your lordship. This is a notification of 2025, my lord.
How many years they can take?
It can take 6 years. In the meanwhile, I was continually approaching the authority. They said that you are not eligible to give any exam. But in the meanwhile, I was fully eligible. They didn't even issue me a provisional certificate till date.
Take notice then.
Okay.
Emergent notice. Controller of examination.
Yes, your lordship.
No. Registrar of the controller of
Date of-
already emergent notice.
Item 5.
Returnable within 4 weeks.
May I please, your lordship?
Yes.
Well, petition is a primary school teachers. Prope number 15. Earlier being aggravated order of transfer, he had approached the positional report. Lordship directed to disclose the reference of but mark case has been rejected because petitioner is a physical handicap person. He has transferred in 35 kilometer distance. Also,
Make use of the mic because others are disturbing you. Yes.
well, petitioner is a primary school teacher. Earlier he had approached the positional report for his aggravated order of transfer.
Let the file short objection.
There is a problem
Rejected also.
in the guideline issued in 14th May 2025. There is a provision for appeal before the director.
You file appeal
No.
because no appeal.
No.
Appeal is provided.
Yes.
And
And
departmental appeal, na?
Yes.
Further says departmental appeal if there is. You have to explore that.
Your Lordship, direct.
Petition prayer reads as under. First one, petitioner seeks quashment of the order dated 26/9/2025. A copy whereof awaits at Annexure 6 whereby his request for accommodation in the nearby school by way of transfer is negative. First one.
guideline rule.
Look at the next. UGA, Mr. Linka points out that under the subject transfer guidelines,
Yes.
Departmental appeal lies to whom?
Director.
To the director of elementary.
Director elementary.
Director of elementary education.
Yes. Director secondary education.
Director of
Elementary.
secondary. What is the yes, brother?
Elementary.
Elementary. Elementary.
Private school.
You are a primary school,
Private
huh?
school or elementary?
Elementary.
Then director secretary.
Director of Elementary Education, and therefore petitioner should be relegated to avail the alternate and equally efficacious remedy. First, there is force in this submission. Next, in the above circumstances, the petition is disposed of. Measuring liberty to the petitioner to file the departmental appeal within 2 weeks.
Yes, sir.
And if one is filed, the same shall be heard and decided within 4 weeks next following, on merits and without raising the issue of appeal. First, all contentions kept over.
Yes, sir.
Next.
Item 6.
May please allow me. Lord, here the petitioner was promoted to the post of a headmaster. He was serving as a TGT, my lord, as an assistant teacher, and we found eligible, was senior most, he was promoted. And there, may kindly look at an annexed 21.
Your promotion should be approved.
Yes, my lord.
Annex 30, page 82, representation is filed before the director of secondary education.
To consider that.
Yes.
They are not doing that, my lord. Lot of representations have been given.
I direct them to do. Still they will not do.
That will do, my lord. They will take. Unfortunately, they will mobilize, my lord.
They will do that. Wait, I'll fix that period also. Within that period, they should dispose of. Otherwise, you can move an application for being cost. I will levy the cost. But short grievance of the petitioner is reflected in the prayer column. First cost. Petitioner draws attention of this court his representation dated
4/8/25.
4/8/2025, a copy whereof awaits at Annex 30. It is a request for taking step for approval of promotion made in favor of the Kishore Bhag. That's the petitioner.
Yes, my lord.
Made in favor of petitioner. Given to the petitioner to the post of headmaster with the retrospective and to dispose of GRC number 616 of 2020. Council submits that unless a report intervenes, in the state of Orissa, things do not move from table to table because of the bureaucratic approach. First, this court shares that opinion in the light of so many cases being seen of that kind. First, be that next one. Mr. Lenka, appearing for the OPs, very fairly submits that he would instruct who should take the decision.
Director, opposite party 2.
OP number, inspect OP number 2, to look into the grievance of the petitioner, provided a reasonable period is prescribed and all contentions are kept over. First off, he also tells the court that petitioner should also cooperate in producing required records, if any, if it. First off, counsel for the petitioner is agreeable with this proposal. Next paragraph. 8 weeks. Open to solicit. If delay is proved, the OP number 2 shall pay ₹500 per day to the petitioner. To the petitioner.
Item 7.
Till the decision is taken. Make it 250. 250 rupees per day. So that 7,500 you will have every month.
Well, the Lord fixed a day, particular period.
Stop. 8 weeks. Yes.
Obliged.
But after seeing this last part, he may pass an order against you. I leave it to your should it be there or not? Because he may take it.
That is expected, my lord.
Huh?
That is expected.
Expected. Then let it next again with that comes. Yes.
You must.
May I please allow you?
Yes.
It's a case wherein the petitioner paid for a direction.
Two identical cases,
Yes.
lordship.
Yes.
Before puja vacation, directed the collector to to make a arrangement for discussion with the truck owners association, and SP will also remain present. And in the meantime, the collector has discussed with all the stakeholders, and we have also filed counter affidavit in those cases. So you will,
Issue this notice and we'll call this matter along with you.
yes.
Next week, yes.
No, along with that, I will call them.
Yes, along with that matter.
Issue number 10 for this. Mr. Lenka, I request you to accept notice for 1 to
1 5.
4.
1 to 5.
5.
Yes, Your Lord.
LIC.
IIC, man.
IIC.
That is IIC.
1 to 5. First, emergent would wish to rest to the rest first. From this matter along with WP number.
I have given them.
Yes. Next.
Item 8.
Next date may be fixed, it can be disposed of.
If we have fixed date,
In that cases, your lordship have directed that to release this matter immediately after puja vacation. But inevitably the matter has not been listed.
post this matter in the second week of December 2020.
Great.
No, this item number 8 is similar to WPC number 1.
Boss,
Malo.
I should tell one thing.
Malo.
I came to this court in May 2025. Put 7 months are over. I have been the quality of the bar has reached because of my badness.
No, your lordship's ability to guide us.
No.
I'm not.
These youngsters are doing so well. I feel very happy. Really. They are doing so. They are bringing the law. Thus, they are bringing statute decisions. Thus is working out as to what she should do to me. I am appreciating the young members of bar. You don't agree with my certificate?
I was concentrating this. I was thinking other way. I was
ownership. The young bar has improved. Otherwise, the whole entire bar would have been in the fist of very few, which I am against. Youngsters are doing so well. They are doing very well. They speak by using the mic. Therefore, I have to be lenient to them. I have to put 5 marks more when they use the mic. Yes.
My lord,
I-
this
my
is,
lord,
yes,
I filed a petition.
let it
I
be
filed-
information be there, my lord, I am not. My lord, it is connected to WPC number 12,869 of 25, which your lordship has posted to Monday, this Monday, sir.
Question.
Yes.
Let it come on, man.
My lord, may kindly.
Yes, sir.
Your lordship may kindly see the last order which your lordship has passed and annexed to the IA.
Yes.
This IA has been filed, but it has not come to the record. Your lordship has kept certain seats vacant for those persons. Same may be passed here, my lord. I have no.
That is my anxiety. Now, that was on 9/10, almost 1 month back. At that moment, we have given, though I have filed a petition for vacation of stay, but we have considered because only one petition was there.
No, 11
that was the order.
11
My lord passed that order, that's one seat pushed.
11 posted.
Now, as I have understood, my lord, 3-4 cases have been tagged to this case because my lord have granted a stay order necessarily
Everybody is
protecting. Everybody is coming. Entire endeavor will be stopped.
No, your lordship
It
is
may be
posted.
hard, my lord.
Your lordship
And
is
the
posted.
examination.
No.
We'll call this a matter on Monday, no order today.
Along with my lord, WPC number.
You there.
Yes.
It's on it. Please don't.
My lord, my interim application may be also called for because this has not come to the record.
They just need to post all petitions. Yeah.
Monday along with I'm giving the.
Along with-
ठीक है से दे दियो से पता है कोर्ट उसको के नंबर का देना हम दे दो से अपन को 8 बैंक नंबर का दे दे आगे नहीं
And annexure 2 is the notice which is issued by opposite party.
I'm sorry, madam. Sorry. Well, that number I'm giving, this will be tagged to that. And my IA may be considered if your lordship considers the main application on that day.
Done. Next.
Item 9.
And the annexure 2 is before your lordship. The petitioner daughter is a petitioner daughter is a minor daughter who representing for sports as a badminton players in the state of Orissa in different categories under 15 and under 17. The petitioner was some certain irregularities made by the OP number 5, the Badminton Association of Odisha. The petitioner made a 18 report before the Nandankan police station. Same was registered under section 468, 471 and other offences of IPC.
Abduction. Of kidnapping and abduction.
No. See, register a FIR under section 47, forgery.
Forgery.
Forgery by the OP number 5. The petitioner is the mother of the minor daughter who representing as a badminton player in throughout the states and getting medals from different categories under 15 and under 17 likely. After registration of affair, the OP number 5, the association issue a notice to not to allow the petitioner, being the mother of the minor child, a stadium where the athletes was made, which was challenged before. Thereafter, I made a series of representation before the state authority, but they do not take any action.
Whether Orissa Badminton Association is a state under Article 12. It's a society.
Society.
Is it funded by the government?
It was aided by the state.
Huh?
It was aided by the state.
How much aid is given?
Pardon me.
How much aid? If the government gives 500 rupees per year, it does not become the state. It should have, government should have, you have seen that, which is that famous judgment, the R.D. Shetty. The government should have a pervasive control, number one. Or it should have substantially funded.
Public duty is not
Duty, etc. This thing. Where is the petition ever made to that effect?
That what I
File a suit.
The representation was sub judice before.
But everybody will come with a representation to establish a jackfruit stall in KR market. How can I entertain that? We have to go by law. You have appointed me as a judge because I will decide the matters in accordance with law, not according to like a Mughal. Okay. Petition prayer reads as under. First, when asked as to whether the Orissa Badminton Association is an instrumentality of state under Article 12 of the Constitution of India, in the light of Ajay Hasia versus Khalid Mujib Surawardi, the counsel for the petitioner is not in a position to explain on the basis of pleadings which he had put before the court. First, Mr. Lenka, AGA, Mr. Lenka, appearing for the petitioner of OPs, official OPs, submits that in matters like this, writ remedy is misconceived, to say the least. First off, he adds that in the light of Ajay Supra, petition itself is not made with. First off, I share that. Next, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to work out his remedy either through a suit or otherwise in accordance with law elsewhere. First off, at connection, all contentions of the parties are kept open. Registry to send a copy of this order to Opinum, go to the cast title.
OP number
OP number
5.
5 and 6. 5 and 6. Speed post immediately. Next.
Item 10. Item 10.
What is this matter?
He wants to release of amount.
Pledging the deposit.
I'm sorry.
All right. No. You need not be sorry. Sometimes there are many courts, you go to other court and thereafter you come here. You need not be sorry. Yes. You want the release of the maturity
Release
amount.
of the maturity amount.
Who appears for the OPs?
OP's government is there.
What is
but,
that?
Security amount, my lord, for opening +2 science college and for obtaining temporary
Notice to the bank is necessary.
AG requested to accept notice for OP numbers 1, 2,
2 and 4.
No, Secretary Council of
One panel. Council of
emergent notice to 3 and to 5. Matter lies in an hour compass, posted in the 3rd week of December.
Item 11.
Pardon, my lordship.
Yes, sir.
A present writ petition has been filed challenging inaction of the opposite party in the matter of section non-action of RSCP and MSCP under ORSP Rule 2008-17. Read with the Financial Department resolution dated 6 February 2013. So
Could of directing that consider representation.
Lordship.
Where is your representation?
Ashok Mahapatra.
Now, where is the representation?
He has not filed lordship direct to
You
file.
have representation.
Annex of 4, my lord.
So that
Annexure 4 is the order of the director. madam.
this is order of the Director of Secondary Education. Where is your? You
Yes,
make
my lord.
within 2 weeks.
Yes, my lord.
Petition prayer reads as under. First, learned ASC, Mr. Sen, appearing for the OP, submits that the law of writ is well settled by this time, Constitution having come into force since last 75 years, and therefore, without a demand and rejection, a writ of mandamus cannot be sought for. First up, in support of this review, the attention of the court to Justice V.L. Hansariya's writ jurisdiction under the Constitution. Universal. First up, there is force in this submission. Ordinarily, report would expect a demand from the citizen, by the citizen, before knocking at the door, before knocking at its doors. First, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation to the jurisdictional OP for redressing his grievance, if any, as has been structured in the writ petition within 2 weeks. First, such a representation is made, the jurisdictional OP shall consider the same and in result of such consideration to the petitioner within 8 weeks. First of all, contentions are kept open. No cost, web copy.
Item 12, yesterday one matter disposed of, I've corrected. That order is covered by the, he is covered by that writ appeal court order, the years.
Just okay, give copy to him.
I have given him, I've given it.
Both the copies you are given to the
Yes, because 2 cases are there.
2 separate cases.
I've just
Considering the
yes, that's a 5 representation is to be considered in light of the judgment. That was the order. Yesterday one matter was there.
Brother Sen, we will do that, Your Lordship. Yeah.
Your Lordship, I'm standing here on behalf of Counsel Saroj Kumar Padi. Your Lordship, this application is seeking for direction to to the opposite parties to regularize the service of the petitioner as full-time physical education instructor. The petitioner has given 12 years of unblemished service here, and Your Lordship, if I may, part-time.
How many hours?
12 years has already been done.
How many hours?
Hours, Your Lordship.
How to decide whether or full timer? On what are the normative basis for that?
Your Lordship, if the petitioner has given 12 years or more years of uninterrupted service. Yes, sir. Yes, Your Lordship. The petitioner was.
You can address me as sir also.
Yeah. Your Lordship, the petitioner was recruited through regular service.
Where is your
recruitment service?
Where is your
Annexure 6, Annexure 5 series, Your Lordship, page number 24 to 27.
If direction is given to consider that, you will be happy.
Yes, Your Lordship.
Brother,
Your Lordship, you have also given a similar order in the case of Sobhagya Ranjan. Sorry.
By other judge?
No, Your Lordship.
By me only?
Yes.
The case I have heard this.
Yes.
Same order. Jago.
Lordship.
Yes, series. Sister, Annexure S series.
Annexure 5 series.
5 series.
Yes, Your Lordship, I have also corrected it in the judgment, in the order.
Most of the bar members are, I'm very happy, they are bringing the draft judgment itself. Earlier we used to file draft issues. That's how draft judgment is. Consider that.
That's
Thank you.
Yeah.
Obliged.
No problem. But in a British court, when I went to UK, I attended the English court. They will say thanks to the judge. But here we get offended. I don't know why we get offended when a lawyer says thank you. It's a gratitude of law. Yes.
Madam, matter relating to RSP matter?
Recipe. Yes.
But both the matter, madam.
Yes. You have given copy?
Yes.
Both in both connected matters also?
My lord. Connected also.
Next.
Item 15.
The petitioner in this case claiming annual increment has not been paid during the period of suspension. Identical matter has the Hon'Ble Court under Annexure 3 has been upheld by the division bench and confirmed by the appeals court. The petitioner made representation under Annexure 4 before the opposite party number 4. Taking into Annexure 3, my lord, it may be considered.
For revoking suspension?
No, sir.
Payment of subsistence?
Annual increment during the period of suspension.
The short grievance of the petitioner is as to denial of annual increment on the ground that he was under suspension in the relevant period. First, counsel for the petitioner submits that law having been already declared by the apex court, the period of suspension counsel for the petitioner submits that the client has already made a representation dated
31/7/2020.
31/10/2020. Four, which reads as that. Next paragraph. Counsel complains that in the state of Orissa, the officials do not consider and pass orders on the representations of the kind sans interference of writ court. First off, this court shares the same opinion, having seen several such cases day in and day out. First off, next paragraph. One sentence, be that as it may. Next paragraph. Learned ASC Mr. Sen agrees to Mr. OP number 4 to look into the grievance of the petitioner, as has been aired in the subject representation in a time-bound way, if all contentions are kept open and a reasonable period is prescribed. First off, with this proposal, counsel for the petitioner quarters. Next, in the above circumstances,
The representation itself, no manner of communication is there.
Within a period of
8 weeks.
Taking into consideration the decision by the Annexure 3.
It hardly needs to be stated that the decision has to be taken, keeping in view the apex court ruling and this honorable court's ruling, coordinate bench ruling, coordinate bench or division bench, and the division bench ruling of this court, copies whereof are produced at Annexure 3.
Annexure 3 series.
3 series. Okay. Next.
Item 16.
Here, my lord, petitioner, the primary school teachers, my lord, and also member of the primary school association. Here, my lord, what happens in this case, my lord, government in the process of digitalization, they have decided to take e-attendance and other things all through internet. And for that process, they have decided to distribute tablets at the rate of 20 per school, my lord. Consequently, it has been restricted to 1 tablet per school. My lord, without doing that, my lord, now the government is forcing us to use our own mobile for using that system, my lord, unified automated system.
Your mic,
my lord.
How you are agreeing?
My lord?
How you are accused? Suppose if the government passes an order saying that you should put your signature
Yes, my lord.
by your own pen.
Yes, my lord. Here, my lord, we have to compelling to use download third-party apps, my lord, which is violation to privacy, my lord. Third-party apps, my lord, I have to download, and we have to bear our own cost, my lord.
Brother, the cost also you are not paying for that. You can't ask a citizen to pay 50 paise from his pocket. Where is the authority of law? Take notice. Emergent notice. ASA accepts notice for OP number, my lord. 2. OP number, all the cost of this, all groups. Matter lies in a narrow compass, call in the 3rd week of December 24.
Here, my lord, the government is threatening us to, my lord, what time they are threatening us to salary cut and no coercive acts, my lord, dear lordship. They are asking for salary cuts and other disciplinary actions, my lord.
The next date of CAT. No precipitatory step shall be taken under the impugned action.
Okay. Obviously.
Item 17.
That is correct, covered by that Loknath Behra.
Covered.
Loknath Behra. Both cases same.
Give that copy. Just a moment. Look to Yes.
Item 18.
May I please, Your Lordship?
Yes, sir.
Here the petitioner of lordship is subjected to hostile and subjective discrimination. I am saying that because your lordship can have a glance to page 27, Annex 3. There, as many as one.
Take notice.
That's
Take notice.
in all cases. They have made the application of the financial benefit from the date of assuming the charge of the TGT. In the case of the petitioners only, it has been made applicable from the date of the issuance of the order.
Mr. Singh, accept no?
Lordship.
Then accepts notice. Matter lies in a narrow compass, call in the 3rd week of December. Okay.
Item 19.
Covered.
Yes, on sub items.
Sub items also.
Yes.
Separately you are rectified.
Yes.
Same order. For all the 3.
All the yes. I have collected round of.
Is reader in not history.
Pardon?
Reader in what? History.
No. I have that. I have rounded off, my lord. As for my repetition, that may be mentioned, my lord.
In what are they actually?
Pardon?
Which branch they are teaching?
My lord, all the 3 matters, my lord.
First matter, my lord, is the reader in the. Edited.
Not detailed. Detailed or existing, my lord.
Whatever is you have, what you change the dates and other things.
My lord, I have changed. I have rounded up.
No, you have only rounded up.
As for my repetition, my lord, that will be mentioned, my lord.
What I suggest is,
yes,
instead of further, and that will take 1 month now.
Yes.
If you give all particulars, I will post the order today itself. So you change everything and give 3 sets.
Yes. Yes.
Hello. You give 3 sets separately.
Yes.
Mark and individual particulars should be filled up.
Okay.
Give it to. Yes.
Item 20.
Please, your lordship. Lordship, a disciplinary proceeding was initiated under Annexure 1 against the petitioner, as well as with a criminal proceeding. Under Annexure 3, the Sessions and Special Judge Koraput got acquitted the petitioner. Then the disciplinary proceeding was also finished with punishment under Annexure 7. Then the petitioner filed a appeal.
Quashing notice.
Yes.
What is that notice?
Lordship, after
Take me to Annexure 10. Number?
page number 36.
34 valid. 34 valid.
Annexure 10.
Answer 10.
They said you appear in the inquiry. Why should not you appear in the inquiry?
Lordship, the petitioner was the disciplinary proceeding was finished with punishment under Annexure 7, Your Lordship.
Already he is punished.
Yes, Your Lordship. Now,
Is it in respect of the very same proceeding, Mr. Same?
Lordship.
Just look into it. One increment is withheld. And the period of suspension will be treated as such. He is censured also.
Lordship.
Why one more proceeding?
Lordship, I want a short adjournment to take instruction.
Take to emergent notice.
There was a criminal.
Stay of all proceedings pursuant to impugn notice till next date of hearing. Yes.
obliged.
Item 21. First, this interim protection is granted. Brothers, this interim protection is granted on the submission of learned counsel for the petitioner that already he has been, he was subjected to disciplinary inquiry and punished to. Next, item 21.
This is covered by your lordship, sir.
Yeah. You have changed the factors.
Smile.
Item 22. Yes, sir.
Item 21 is the fixation matter. Similar matter, already issued notice.
Similar matters we have issued notice. Your senior wants to assist you.
No, but
You are for the OPs.
University.
Behra will have notice for one. Say panel consent, say two concepts notice for 2 to 4. Matter lies in a narrow compass. Call this matter in the first week of January.
28 matter. Similar matter, posting matter 28 matter. 28/11/2020.
28/11. 28/11. Call this matter along with WP number.
WP number 30549 of 2025.
Give that. Yes. In the meanwhile, it is open to the OPs to file their counter if any. Item 23.
May I please on this?
Yes, sir.
Less on law, my lord, more on mercy of my lords. This is a petitioner, my lord. The petitioners are appointed as a guest teachers. Their appointment was valid till regular post is, my lord, filled up, or new teachers are coming to the post, my lords.
Yes.
We have all the requisite qualification are the advertisement made for this year also. Except in the previous year, at the time of appointment of guest teachers, my lord, OTT was not a mandatory provision. But this advertisement, OTT is mandatory. All the petitioners have the OTT qualifications, man.
All they have.
All they have. But they have not, my lord, given any relaxation in the advertisement of some others, my lord. My humble submission, my lord.
How many years they had served?
Since 23 they are in shop, my lord. I guess the engagement others.
2 years.
2 years. Having all petitions with them, my lords.
Some preference should have been given.
My lords, my humble submission.
My lords, they have challenged the advertisement for regular appointments.
No,
and the engagement was purely temporary for one
till regular recruitment takes place.
Yes, my lord. Now we are going for regular appointments.
Correct. But problem is
they can participate in the process. Nobody obstructs.
They can participate is true. For working 2 years with
no 2 years, man. It is 1 year. 24 में sir.
23. 2020.
My lords, can lead on to page 20.
You take notice. There is one judgment of the apex court. where people having all qualifications have put in irregular service and they are engaged to discharge duties till regular recruitment takes place. Ordinarily, some grace has to be given to them. There are judgments. Though your friend abroad, I have read such judgments. Therefore, take notice and make a statement. I will not halt anything, but issue emergent notice. Mr. Behra, learned AG, has requested to accept notice for all OPs. For OPs. Matter lies in a narrow compass. Therefore, call the same in the second week of December. You have to search and bring those judgments.
I have filed till then.
No halting.
Till regular appointment. I don't, in the next advertisement, I will keep some apprentice relaxations. But some relax, till next date at least.
In fact, there are the judgments of the apex court, conflicting judgments. Judgment is in fact what Mr. Behra said now.
From the beginning, I conceals Malad. It's a mercy pit survey for Malad.
That's one.
Next till next date, Malad, I pray, I will protected and let them find a counter. It will be decided, Malad, for the next advertisement, I can get something. This advertisement cannot.
Mercy is up to a particular. You have to mix mercy with the law. That's the reason. Yes.
Item 24.
May I be minutes?
Yes.
The sub-item is same, Malad.
Mandamus to treat the date of joining of petition.
1 day pre-poning. My prayer is, Lord, for pre-poning of 1 day of date of joining. And you'll also kindly see page 24. That is the recommendation made by the BO to the DO. And the DO said, you are the authority. You'll also kindly see page 24, annex of 4.
Take notice.
You can, once the DO said, demanded matter to the BO, you can direct the BO to decide as per Annex 4. Annex 4 is there, and that they have given benefit to others. That is also I have annexed same benefits.
You consider. I will not direct that way, but let them consider.
All right, let them consider taking into consideration Annex 8 and Annex 4.
8 and 4.
Annex 4. That is the letter dated 7/11/2024, and the Annex 8.
Slow. 7/11/24.
Under Annex 4. That is the one letter of the BO. Recommended. Now the DO said, you are the authority, I am not the authority.
My lord, Annexure 7 is the representation. The lordship, lordship may direct.
Petitioner has submitted a representation to whom you have submitted?
Collector is.
No, BO. BO is the
BO.
BO. Page 30.
On where is the date? 29/9/2025, and a copy of the same is at Annexure 7, page 3. First.
32 double.
One is
representation reads.
That's two petitioners. One is 29/9/25, and another is 6/6/25.
Petitioners have given representation. First off. One sample copy of the representation dated 29/9/2025 made by petitioner in WPC 32003 of 2025 is produced for ease of reference. First off. Next paragraph. Learned counsel for the petitioner submits in the state of Orissa, without interference of the writ court, representations of the kind are not being considered, and that this court has been seeing a series of such cases every day. First off, this is a truth, although it is a stark truth. First one. Next paragraph. Learned AGA, Mr. Behra, I am making grounds so that in one case, I will blast the government with the 50 lakh costs. That is the reason.
No, here in this case, my case, this is not attractive.
Mr. Behra, learned AGA, on request appearing for the OPs, submits that he would instruct the OP number 5 to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way if contentions are kept open. First off, with this counsel for the petitioner stands tall and agrees. First off.
So it's a tall that will repeat it.
Yeah, it's a tall. Standing tall means is something. Otherwise, also you are tall, no?
No, that,
Yes.
that's really reflected in the.
8 feet.
It's to direct criminals to look into the grievance. Take into consideration Annex of 4. Take into consideration Annex of 4 and Annex of 7.
Consideration should happen in the light of recommendations.
Yes, recounts Annex of 4.
Recommendations respectively at Annexer 4 and Annexer
8.
Annexer 4 in this, 8 in that.
No, this case, only one man, my lord, not two cases. One case is 2%. Lordship.
Annexers 4 and
8.
8.
Well, if the VO has written to DO, if he is competent, why you will write?
And the DO said you are the competent. 6. Kindly see Annex 6.
You direct jurisdictional OPs instead of BU. Jurisdictional OPs. Yes, whoever.
Now the DO said the BO. You are the competent authority.
So therefore I have protected you, saying that whoever is the competent authority, he will instruct them. Because you can't decide whether he has power or that person has power. It is for them to decide.
Lordship may fix a time limit.
8 weeks. Okay.
Item 25.
Item 25.
Yes.
Petitioner in this case, you approach this Hon'Ble Court, my lord have passed order to file an appeal. And
what happened to appeal now? Annexer to decide rejected.
No, not rejected, but there, my lord have protected under page 34 that what they are not allowing me to continue.
Mr. Behra.
My lords, page 41, it shows that he has called for hearing.
But they neither they have not finalized my appeal nor they have not allowed. And in the meantime, also I have enclosed in my appeal that MLA MP cannot my lord transfer and that matter is sub judice. That order I have also enclosed page 38 with my appeal person also. On the basis of the recommendation of the MLA MP, I have been transferred. But my order I have protected to file an appeal and I have appealed. But they are not allowing me to. That only my.
Why not allowing, sir? You take notice. This matter.
Instruction.
Monday. We'll call this matter.
Let's 1 week after.
1 week. Issue emergent notice. Mr. Behra accepts notice. AG accepts notice for OPs. First of all. He also assures the court that he will look into the grievance of the petitioner. After conferring with his official clients. First of all this matter next week. Since it involves a short. Okay.
Item 26.
May I please, Lords? My lord, here the salary of the petitioners is being withheld since July 2025 without any order to that effect. Because
you have got service now. How many years of service you have got? What's your age now?
I am 45 years old.
45.
Yes.
So the age of retirement is 60.
60.
So another 15 years.
15 years.
Mr. Behra, look into this and I will call this matter next week.
My lords,
or you will consider the representation.
My lords, here
they will reject it.
The disciplinary proceeding was initiated.
Initiated. But how can salary be withheld unless punishment is ordered?
That is stayed by your lordships.
No, in other ways.
In other ways. Yes.
In the absence of punishment order, how can you withhold the salary? If direction is given for consideration, will it be helpful to you or they will reject it?
They will reject it.
I'll take instruction. Your lordship may call 1 week after.
Call this matter week after next, since it lies in a narrow compass. Okay. Which is that other matter?
Well, that WPC 24178 of 25.
All this matter along with the.
That is Annexure 9. I have given that order.
That fine. That. Yeah.
Item 27.
Yes. Well, my application for mutual transfer has been rejected by applying that clause 2L
Similar matter what we did. You that clause is excluded.
Yes, yes. That is only meant for district cadet teacher.
My lord, the guideline says.
No, that is for district cadet teachers.
No.
Cadet teacher. Lordship may kindly see the guidelines. Possibly my learned friend was not there at the relevant time. Lordship may kindly come to Annexure 5. That is the guidelines.
Yes, Mr. Behra, other day we looked into that.
Case 31. That is meant
that is for
district cadet teachers.
They're excluded. The other category is excluded.
Similar matter notice has been issued.
One notice we are issuing, na? Issue emergent notice. Mr. Behra accepts notice.
All these matters have been fixed to 19th.
Along with WP number.
Yes, sir.
22.
92.
And other connected matters.
Yes.
They are on the?
Yes.
90.
90.
In the meanwhile, it is open to wish to file a counter if fixed.
32 is also same.
32 also same. Item 28.
Here I have challenged the transfer order. I have challenged the transfer order on 2 grounds. First is on the recommendation of the MLA, and second is it is without jurisdiction. Because your Lordship may kindly see the guidelines. This is meant for secondary schools. Your Lordship may kindly come to page 33.
Yours is not secondary school.
No, mine is a secondary school. Your Lordship may kindly see who is the competent authority. Here the order has been passed by the district education officer. My Lord may kindly see.
A similar matter you argued?
Yes, I argued. My Lord, so far as, my Lord, during the normal period, that is up to 31st June 2025, the competent authority is the district education officer.
EO.
If it goes beyond that,
Director.
then the director. And this order has been passed by the district education officer, and it is a vice versa transfer order. My Lord may kindly turn to Annexure 3. The opposite party number 4 who is coming to my place on the recommendation of the MLA. This is a case of accommodation also.
Please send MLAs.
My Lord.
My Lord, so far present petitioner is concerned, he has not transferred on recommendation of MLA.
Vice versa transfer.
No, my Lord, kindly see.
Mutual transfer it is.
Page 21.
You requested for a...
No, not mutual. Well, this is a vice versa transfer order. So far as the opposite party number 4 is concerned,
transferred to your place.
My place on the recommendation of the MLA. And I have been transferred to his place. It is a clear case of
transfer is not on the basis of the recommendation.
If other transfer is done at the instance of MLA and he is displaced, then also that ground is...
My Lord, there is a circular to transfer all who have completed 3 years of service. Rationalization. Rationalization is on that administrative ground he has been transferred.
Well,
he has not been
transferred nothing.
You have transferred him because
you accommodate
Shilpi post. If emergent notice, AG is requested to accept notice for.
My Lord, transfer order is also available. Let him file.
No. My Lord has fixed all these cases.
We are considering.
Here MLA will not come.
MLA comes. Not at his level.
Yes.
At the level of the other, the person who has been transferred to his place. MLA figures then.
Yes.
Anyway, I have not made up my mind this way, that way, because I have to
that will finally ask.
17 is allowed.
Issue emergent notice. Mr. Behra, the DG requested to accept notice for 124. Emergent notice to 5 and 6, 4 and 5.
Yes.
4 and 5. MLA also you made a party.
Yes. And I have also challenged that circular.
4 and 5. Interim order as prayed for. Stay of impugned order. So far the petitioner is concerned. Till next date of
petitioner and OP number 4.
Petitioner and OP number 4.
My Lord, this is passed on 23rd September. 40 days have
Whether you
passed.
have been relieved.
No, I am not. I am not.
You are not
Say that you are not, if you are relieved, then you will not.
Otherwise,
Your Lordship may indicate that. Your Lordship may indicate that I may be allowed to continue with my previous post.
If, no, not no, if already not relieved. If not relieved, we can protect you.
otherwise,
Yes, students.
2 persons will.
Then call this matter along with WP number.
That is WC number 23834 up to 1025.
That, give that.
Yes.
Open 49.
Exactly, Your Lordship.
Yes, sir.
The petitioner was a labor for of elementary education service teacher. And for appointment get the post of CRCC pilot, that is cluster resources center coordinator, that post. There is a
notice.
There is a mild reversion here, mild. There is a written test. I was test. I was selected along with near about 500 teachers. 4 teachers were selected for 5 years. They will be appointed as CRCC pilot. I was appointed as CRCC under Annex 4 milord. You will also kindly see on 12/4/2022. Before completion of 5 years, the collector has reverted me to my parent post pilot.
Impugned order is dated?
Dated 7/11/2025 pilot.
Issue emergent notice.
My lords, kindly see Annex 4, my lords.
Yes.
There is no stipulation that he continue for 5 years.
In submission. Yes.
5 years stipulation is not there. And this is not a separate posting. They have reverted to their parent post.
Reversion to, not a reversion from higher post to lower post.
No.
It is what is sending you back to the parent
That is getting the special written test is conducted, Viva's test is conducted. Among the 500 teachers I was selected for 5 years. You will also kind
No, what is your right to remain on deputation?
That is for my deployment for 5 years.
It may be. Now they are sending you back.
Service career once I will be there for 5 years. Thereafter, I cannot be eligible, my lord. You will also kindly come to page 20, my lord, clause 12, my lord.
Page 20?
20, clause 12.
Well, shall be engaged.
He will be engaged as CRCC for a period of 5 years on the basis of reasoning test. After completion of 5 years of tenure, she or he will be reverted back to their parent post, my lord. I am getting extra benefits and written test you will also kindly come to page 10, my lord. Written test, discussion, Viva's test.
1 second. Yes, what is this order? This order is issued under which section of law? Which law?
That is, my lord, the elementary cadre service, the elementary education service does not provide for CRCC, my lord. It is scheme under the Samagra Shiksha Abhijan.
No, under which statute this scheme is?
There is no statute. That is scheme, my lord, sponsored by either central government, my lord. That is.
You are not answering question.
Yes, my lord.
I am asking you, this scheme is drawn by central government or state government?
It is a central government scheme.
That central government has drawn this scheme
under the right to the
Education Act. Show that.
That I got, my lord.
Give the Right to Education Act too, sir. Sir. Right to Education, RT. Sir. How many years are over now after?
Another 2.5 years. 3.5 years have gone. Another 1.5 years. Well, nothing, no allegation. They should give me the so-called.
No,
nothing, no so-called.
You are not being removed from the service.
Not from
this place to
from a special post to my lord, to my parent post, my lord. Because, my lord, I was appointed on the basis of selection, facing the written test and a Viva's test, my lord. Those 2 tests I have faced, my lord. I have selected among the 500 teachers, my lord.
Which section? To others also you have done like this. Huh?
My lords, Annexer 5 itself shows 5 persons.
It is not that he is singled out.
5 persons are, my lord. Without any so-called, without any
so-called. Where is you are being removed? You are not removed.
I am not removed. I am removed from a special post, my lord, during my service career. Once I can be eligible, my lord. Unless there is selection test or any written test or vice test, I was not selected and the authority appointed me, my lord, against that special post, I can be reverted back, my lord. But you are doing a selection test for 5 years to be posted against that post, my lord.
Now they want, how you are aggrieved?
Aggrieved, I am not getting the special, that special.
That is not understood. As long as you continue,
I will
be
be, my lord, I will be deprived of getting a higher scale of pay, my lord.
dismissed on the ground that the petitioner does not have a coherent cause of action in as much as petitioner along with other has been repatriated to the parent department. But the apex court, which is 75, 70, 78 or 79, take out, has held that a person on deputation ordinarily does not have the right to remain on the deputation horse, subject to all just exceptions. First, by going back to the parent department, no legal injury has passed in as much as all service conditions are duly protected. First, the vehement submission of learned counsel for the petitioner that his client was selected in the due selection process and that he was assured a tenure of 5 years in terms of clause 12. Clause 12 of Annexure 3. Annexure 3 would not come to, does not merit gain acceptance, since the policy guideline does not have statutory force. First, on being asked whether the scheme in question is drawn under the provisions of any statute, the counsel for the petitioner, although said yes, could not locate the particular provision in the Right to Education Act 2009, 2006 or 9?
Your Lordship, I will give that, my lord. Your Lordship, I will give that provision.
You have to come with full preparation to the court. If you were to be youngster, I would have agreed. Yes. Yeah, it is only an executive instruction. The apex court in state of Mysore, CD Fernandez, held that the violation of executive instructions ordinarily would not be justiciable under Article 226 of the Constitution of India. They got that for Mysore also, so which is that judgment? 60s. 1967 AC. Right. The above circumstances, petition being unworthy of merits is liable to be rejected, and accordingly it is. Put one sentence. Mr. Behra argued like this. Yes.
May I please?
Yes.
Petitioner, my lord, applied for the trained graduate teacher for pursuant to the advertising under Annexure 1, my lord. A written test was conducted and a model answer key was also published by opposite partner 3. As per the calculation, petitioner is securing 72 marks and petitioner was asked to submit document for verification. Petitioner submitted the document for verification. Annexure 7, a merit list was published, though indicating the last SC category, since petitioner belonged to SC category, was 71.75, even though petitioner tallied his mark from the model answer vis-a-vis his OMR mark sheet that he is securing 72 mark. But they will fill up in 15th, my lord. My lord have already passed in similar.
They are subject to...
No, only one for that particular person, my lord. Because
we filled up what happened. We will say it should be subject to...
Yesterday, your lordship, subject to. Yesterday,
I have seen that order, I rejected it.
Yes.
that I didn't know.
And staff selection.
May indicate that in the...
I will be subject to outcome of the petition.
In the event petitioner...
Tell it in the appointment order also.
In the event petitioner succeed, then the last person is to... In the event petition.
Issue emergent notice, AGA to accept notice 1292. Special panel, the panel counsel Sri so and so is requested to accept notice for 3. First, a petition to petitioner to serve copy of the petition on the panel council. Next paragraph. The selection and appointment to the post in question shall be subject to outcome of the writ petition. First, the appointing authority shall, in so many words, mention about this in the appointment order, if any, given to any other candidate.
That PGT
On this matter, along with the
along with that WPC number 30303 of 25.
30303 of 25.
इधर नहीं जानता.
Item 31. Yes, please, Your Lordship. Your Lordship, the petitioner is seeking direction from the court for selection of the post to the TGT PCM, Your Lordship. Your Lordship, an advertisement was floated, Your Lordship, for 1022 post, Your Lordship, and where the petitioner has been selected and called for document verification under Annexure 4 series, Your Lordship.
Now what happened?
Now, Your Lordship, thereafter the petitioner made such a representation as well as objection to the chairman as well as the secretary, OP number 2, Your Lordship. But, Your Lordship, so far as her disclosure of her mark, Your Lordship, disclosure of her mark, and Your Lordship, kindly have a glance to the advertisement clause, Your Lordship, page 25.
25.
Yes, Your Lordship.
Go to 20.
Clause 11.
Clause 11.
11, subclause C. Sharing of marks with candidate. Clause C, subclause 2, Your Lordship, 26 page. Thereafter, if the preliminary examination or main written examination is conducted in CBRE mode, then the candidate's answer sheet along with marks awarded for each question will be provided to the candidates who appeared the examination through their candidate login. While inviting objection to answer key or final answer to the key, they have to keep a print copy of the answer sheet for future reference. Answer sheet and marks secured by the candidates in CBRE exam will not be provided again. And thereafter, Your Lordship, clause E, may kindly have a glance. If a candidate scoring more than last selection marks at the tier or stage of examination is not qualified for the subsequent stage or final selection due to any reason, he must submit representation to the commission 15 days of the declaration of the result.
You made that representation?
Yes, Your Lordship. Under Annex
to that representation?
They have not taken any decision. Now they are going to hold the orientation program, Your Lordship.
I will not halt all that. You take emergent notice. Mr. Behera.
For one.
You appear for one.
Yes.
And Sri Patnaik. Who is the panel counsel?
Mr. Sanjeev Swain, Your Lordship.
Sandeep Swain. Then the panel counsel is requested to accept notice for 2. First, any exercise pursuant to impugned orders shall be subject to outcome of the petition.
Lordship, one post may be kept as otherwise it will infectious, Lordship.
Why infectious? We will say a person who is appointed.
Your Lordship may say that pending of this writ petition, they may dispose of the representation.
The pendency of writ petition will not come in the way of disposal of petitioner representation dated.
Your Lordship, dated 6th November.
6/11/2025 at an exam.
Lordship, subject to result of this
petition.
Grateful.
Item 32 has been adjourned. Item 33.
Item 33, please, Your Lordship. This writ petition is filed seeking a direction.
My lord, it is the Union Open is a party that didn't serve the copy. My lord, associate is there in the court itself.
The file copy.
My lord will serve the copy. My lord, there is just one discrepancy, my lord, that the deadline is today. In round 3 of this.
Unless you lodge a copy with DST,
my lord,
you will not be in a position to do that. Which rule says copy should be served on you, advance copy to be served on you?
My lord, that is Orissa High Court rules 43, no?
Chapter 15, Rule 4. Rule 4. Take up, read. I did not know.
Order or writ is sought against the government or a Under the government, a copy of the application with connections, if any, shall be served on the Advocate General not later than the noon of the day preceding that on which application is moved. When such direction, order, or writ is sought against any department of the state or any statutory authority or any public officer acting or purporting to act under a statute and counsel engaged by such department or office, such a notice shall also be served on such counsel.
What in the second part?
Minus.
My lord, may
Thorough copy.
take this up after lunch, my lord, if.
In the meanwhile, you take a copy. Yeah. Pass on. That is rule 4.
Chapter 15, rule 4.
Chapter 15, rule 4.
Volume 1.
That district concurrent petition, non-compliance of your lordship's order dated 11/9/2025, man.
What was that 11/9 order?
Your lordship directed me to the transfer.
File a
Your lordship
press
directed me
representation.
press representation. They will control within a period of 10 days. Thereafter, I made representation by the annexer next page on 15/9/2025.
16/9.
It was on 16/9.
25.
16/9/2025.
16/9/25.
Restored postal.
Till that, they have not taken
I'll take it.
issue. Who are the parties? Private parties?
private government. Other private, but only one. So,
Who is that? Ananya Das Iyer. Issue police notice.
May I take instruction? Only 10 days left, my lord.
Do not do. Issue police notice to the accused. What they are called? Accused in your contempt rules, what they are called?
contempt.
Contemner.
To the contempt. He is a contemptor. Unless we decide he is a contemptor, how he becomes the? We at the most accused.
Alleged.
Alleged. Will be alleged.
Police no emergent police notice to the contemptor. Contemptor. Returnable within 10 days.
May I take instruction, my lord?
It is open to AGA to take instructions if any. If any. Okay. But you can't represent because the Supreme Court said we cannot spend it.
No, unless they entered appearance, then we cannot, because in person concern.
But you are entitled to approach. But police should stand in front of them. Then things happen.
Because only that it has been communicated on 16/9.
16/9.
By rest post, my lord. We are in.
What is the date today?
10 days. 1 month, my lord.
Just waiting for an appropriate case. Some officers, I want to send them to the jail. I'm just waiting for that. Yes.
May I put up the matter?
Okay. Call this matter on, give a date. In all content matters, date should be fixed for appeal. Yes, sir. Call this matter on so and so on the same date. The contemptor shall be physically present before the court. First time. Next point. However, in the meanwhile a decision is taken, the presence of the contemptor may be dispensed with if a copy of the decision is placed on record. Maybe. Just highlight that word, maybe. No, I may or I may not. Yes, your work will be done now.
December. December.
Give December someday. 9th of December. 9th of December. Yes. These officers are something. Jawaharlal Nehru writes in his autobiography. The Indian civil service is neither Indian nor civil. Jawaharlal Nehru has written this. Same approach even today. He would have said, instead of civil, he would have said Indian, that's all. ICS, no? IAS. Officers will not do. Yeah.
Item 35.
May I lord?
Yes, sister.
My lord, that the petition is the president of the managing committee, Dr. Ambedkar.
shifting Dr. Ambedkar statue. Why? He has given constitution to us. From its present roadside location to inside the premise of government boys high school. Why? Tomorrow some other person will fail. No, you shift it outside. And what is the basis for this? Why it should be shifted? He is the father of constitution, who gave great constitution, great constitution to our country. Why it should be shifted? Because you want. No. Tomorrow somebody says, no, shift it from this place to another place. The government will be engaged only in shifting business. What do you say?
They are saying that because
No, what
of
you
the,
say?
No, it should be placed in a proper place, my lord. Because of the widening of the road, now they are shifting that to some other place. The petitioner's claim is its statue should be shifted to the school premises. That is the sum and substance.
You belong to what? Which school? Government Boys High School.
Government Boys High School. Burla.
How you are associated with this school? Did you study there? Whether children of your client are studying there?
Is President of Managing Committee Dr. Ambedkar Prathamuti.
Is President of?
President Managing Committee Dr. Ambedkar Prathamuti Bhavan.
Mr. Monti, take notice. Just go through. Because such a statue just being left to high and dry in the road makes
should be placed in a proper place at least. Widening of the road cannot be stalled. At the same time, they should also be respected in its proper place. School premises may not be a right place.
Say school premises, but you cannot leave a statue of Dr.
That should be properly placed.
That is not. Issue emergent notice. Right now, heard Learned Council.
Priyanka Priyadarshini Panda.
So and so. Right, so who argued well? Yes, next paragraph. Who argued well and made a case for issuance of emergent first. Mr. Mohanty Lanendi is requested to accept notice for 1 and 2. Emergent notice 2, 3. No, even 1, 2 and 4.
1, 2 and 4. Their panel.
Returnable within 2 weeks. Matter lies in a narrow compass. And some elements of urgency are exhibited and therefore posted in the first week of December. Not problem. Can I revert after that?
Will be rejected under annexure 6 matter.
Take notice.
Permanent notice.
Requested to accept notice for all OPs. All OPs. Yes.
Item 37.
This one option. My lord, so I'm appearing for OP number 3.
Sure, my lord. I am appearing the petitioner, man.
My lord, I need some more time to file the counter. My lord, on the
When
last
it was served on?
My lord?
When the copy of the petition was served on you?
My lord, it was served on 30/10/25, my lord.
30/10.
Yes,
We'll have it in the 3rd week of December.
My
issues. I call the 3rd week of December at the request of Bernard.
My lord, I'm appearing on behalf of Mr. S.N. Patnaik.
Yeah, on the council, Mr. Panel council appearing for.
Absolutely.
3, 2 and 4. No, 3.
3, my lord.
Okay. First, in the meanwhile, counter if any may be filed. Yes.
Obliged, Lord.
Item 38.
My lord, the opposite parties are not extending the time-bound advancement scale of pay in favor of the petitioners.
Time-bound advancement has to be given to you.
Yes.
15, 25, 30.
My lord, then 10, 20, 30 million. My lord, keeping in view this decision, they have this representation, my lord, on 1/9.
Direct.
1/9/2025.
The principal prayer of the petitioner reads as under that A. Next paragraph. Counsel for the petitioner draws attention of the court to the representation dated 1/9/2005 made by his client to whom you have done that?
To the OP number 2, Director Secondary Education.
To OP number 2 at an exact 10.
9, my lord. 9.
But 10 you have written.
10 to the DO.
That is 9 million.
9 is the competent authority.
At an exact 9 and 10.
My lord.
Both. Comma. The former being made to Director Secondary Education and the later being made to the District Education Officer. First of all, he submits that when representations of the kind are made, comma, the officials in the state of Orissa do not act upon this without indulgence of report. First of all, this court also shares the same opinion, having seen such cases day in and day out. First of all. However, this court does not say that the officers are sleeping. Next paragraph. Learned AGA Mr. Mohanty does not now say that the officers are sleeping. Learned AGA Mr. Mohanty, appearing for the OPs, submits that if a reasonable period is prescribed and contentions are kept open, comma, there would be no difficulty for the jurisdictional OPs to take a call on the subject representations and also to inform the petitioner the result of such consideration. First time. This is somewhat appreciable. Next paragraph. In the above circumstances, 6 weeks.
Keeping in view the aforesaid judgments, 4 and 8.
Keeping in view this judgment said
Milord, they have already, this is in paragraph, they have mentioned, Milord.
They have mentioned it also.
Yes, this is in inbuilt.
Keeping in view the decisions mentioned it in apprentices. Okay. Now, no cost. Costs will be imposed on the next level of legal matter. Heavy costs will be imposed on the next level of legal matter. Okay.
Item 39.
Item 39.
I am for the petitioner.
No.
For the orders, I have.
I am for the petitioner.
Vacation of the interim order.
But his intervention application has not yet been allowed.
Which you kindly appreciate.
And the matter is pending before the division bench.
For the entire state's promotion.
Will you not allow me to submit?
That has been
I am for the petitioner. What is this?
It is not in going on merit.
Yes, sir.
No.
On the your intervention application has not yet been allowed. Let me submit.
Yes, Apex could have already laid down the law without making mandate. Without the
like people see how courts run, how lawyers behave in that world. Make it online, the public at large. Yes.
But here what has happened, the virus of Rule 15 has been challenged before the division bench, that is WPC number.
You argue now.
10430 of 2024, that is pending.
Yes.
And secondly, there is a coordinate bench judgment of this honorable court.
You will argue now, we'll start now. Because you can't halt the process itself. You argue now.
But unless those matters are decided.
Before whom they are?
Before the division bench.
Yeah, how you canvass that point also, you consider. You canvass that point also.
Yes. But here, there is a statutory rules.
But how can we this way. How can we stay? Can we hold them for the ransom? How the function of the public officers should happen?
No, Your Lordship may kindly see the impugned order. For a moment, Your Lordship may kindly see the impugned order. And what is the subject matter of challenge before the division bench?
Yeah.
My Lord may kindly see Annexure 4 at page 80. Your Lordship may kindly come to that.
Whether for division bench has stayed the...
No. Division bench has not yet stayed.
Then how can we...
And there is a...
Give the gist of the case. What is the gist of the case?
Well, the gist of the case is, well, there is a statutory rules under Article 309 of the Constitution, that is Elementary Cadre Rules of 1997. The said rules has undergone an amendment in the year 2019 that teachers who were appointed prior to, that is 11 to 2011, well, they are exempted from undergoing OTT training prescribed under the rules.
Teacher eligibility test.
Teacher eligibility test. OTET.
This is exempted.
This is exempted under Rule 15.
Those who have been appointed before 11 to 2011.
All were appointed before 11 to 2011.
Yes.
And some of them have already got promotion to different levels. I am not concerned with that. We are in level 5A. We are seeking our promotion to level 5B of the elementary cadre. There is a coordinate
level 5.
5A.
Level 5, capital A or small a?
Capital A. Of the elementary cadre. Well, we seek promotion to level 5B of the elementary cadre.
Okay.
My Lord, there is a coordinate bench judgment of this Honorable Court dealing with all these points, that so far as level 5A teachers are concerned, my Lord, they did not, those who were appointed prior to that cut-off date 11 to 2011, my Lord, they will be considered for promotion. And, my Lord, after their promotion, the stipulation is there that within 2 years they have to acquire OTT qualification.
Let us read the rule.
Yes. My Lord, may kindly come to page 526.
526, huh?
Who are you people?
Interveners. They are the interveners. They are the subsequent appointee. They were appointed in 2012.
They are qualified candidates of OTT.
Let me submit. Well, you will also may kindly see the provision whose virus is under challenge before the division bench. That the proviso to Rule 15. Elementary cadre rules. Yes.
11.
You Lordship may kindly see Rule 11 first.
Rule 11.
11. Eligibility for promotion.
In order to be eligible for promotion.
In order to be eligible for promotion to the post belonging to level 5B of the service, the candidate must have served for a continuous period of 4 years in the posts belonging to level 5A of the service, provided that 1. 50% of the vacancies shall be filled up by the candidates having passed high school certificate or higher secondary 10+2 examination or graduation with secondary teachers training, public certified teachers course, public diploma in elementary education from any recognized board or university or
contractual junior teachers appointed.
Yes, that is against the advertisement published after 11 to 2011. This is the cut-off date.
One second. Possible. So
And Roman 2.
11 to 2. You are all appointed prior to
11/2/2011.
50% original mechanism, basic findings. Remaining 50 is?
Remaining 50%, same principle that is relating to trained graduate teachers. Trained graduate teachers, either BA BEd or BA CT. The same clause is there. 11/2/2011.
You are right. Now what happened?
Kindly see the impugned order. Annexure 4. Annexure 4 at page 18, which is under challenge. In inviting reference to your file bearing number such and the subject cited above, I am directed to inform you that government, after careful consideration, have been pleased to approve the following. Level 5 pay assistant teachers possessing OTT shall be allowed for promotion to level 5B.
Grievance is number 2.
Yes, grievance is number 2. That
they say you will not be considered.
Considered till writ appeal is decided.
Any stay is there in the writ appeal?
No.
How can you say that?
No.
Yes, what is that?
Well,
Okay,
there in
where is the interdiction?
delay was there and certified. That has been condoned. And on 27/6/2020.
Delay has got it will come to.
Condoned, not condoned.
That is the order,
Rule says they are entitled to. The rule says they are entitled to.
But in the
let me submit. Clarify the position.
Any other points you have got?
Let me clarify. Any other point, let them complete.
Let him answer that point. I will go to other points.
No, if there are other points, so that he can once for all, he can answer all points.
Well, this is the only point. This is the only.
Yes, brother, but yes, why they should be deferred? They shall not be considered.
My lord, I am coming to.
Yeah.
Your lordship will find from the nomenclature of the rule that in exercise of powers conferred by proviso to rule 309. But your lordship, answer is this rule was promulgated in the year 97.
Correct.
But the amendment, the impugned persons, those in which provisions they were given complete exemption, that they have not read, that is 15(2) proviso. All the teachers, those were appointed prior to RCFC Act came into force, they are completely exempted for getting considered to be promotion. But RCFC Act came into force with effect from 1/4/2010.
What is that act?
Yes, madam. Your lordship,
Right to
the central land.
Compulsory Education Act of 2009.
Madam, I'm just coming to madam. I'm just coming to the point boiled for this. Your lordship will find from. Your lordship may kind of. I'm answering to whether this is to prevail or not. Since it is a rule under 309 proviso, whether it will prevail over the central act and the rules framed by the even state government. Answer is no. A.V. Krishna Shripad judgment, Karnataka State's judgment, at the Supreme Court rendered that the power of governor stood to be displaced the moment that particular field is occupied by the legislature's act or rules. Here, your lordship will find. I'm just coming to, but I may kindly turn to first, that is page 7, section 8. Only one line, my lord, I want to bring to.
Section 8. These are appropriate government.
Well, I'm just coming. No, my lord. Appropriate government has been defined. Central government in respect to say central and state government. That is not in dispute. That's why I'm not going to. And the definition of school that is available under section 2N, my lord. All the schools are covered by law. That is not also not in dispute.
No, I should know now.
My lord, then your lordship may kindly turn to 2N, my lord, the definition clause.
School means any recognized imparting elementary education and includes school established owners. Whether you fit into this school.
Yes. Yeah. Cannot be disputed. My lord. Then your lordship kindly turn to section 8, my lord. 8G, my lord. I'm not going to other. Here, after commencement of Article 21A, following the constitutional amendment by 86, my lord, this act was promulgated
to ensure good quality elementary education.
Good quality education.
So the standards are not specified in the schedule.
Then your lordship kindly turn to section 23. My lord, I am coming. Section 23.
Qualification, appointment and terms and conditions of service of teaching.
Can you read, my lord? This is also. But the two may I read, my lord?
As a teacher, where a state does not have adequate institutions offering courses of training, teachers possessing minimum qualifications are let down to one not available in sufficient number. The central government relax the minimum qualification required for the appointment of a teacher for service not exceeding as may be specified in fact qualification.
But may I just
Slowly. You do not need mic at all. I am very happy.
No, my lord. I started reading, my lord, I remain silent.
No, 1 second, sir. What you say is power to relax is with the central government.
Yes. And my lord, I am coming to the next. There is your lordship, first proviso, second proviso. Second proviso came into force to this central act. That is second proviso with on 2017, but giving effect to
1/4/2015.
That says, your lordship kindly have to glance. First proviso, then second proviso. Provided that a teacher who at the commencement of this act does not acquire the minimum qualification,
does not possess.
Or not possess, my lord, sir. Possess. My lord, your lordship, at the commencement of this act, who does not possess the qualification, 5 years relaxation was given initially with the act, principal act, original act. But what happened in the year 2017? It was found, although act came into force for 2010, within 5 years they could not, and different state approach to the state central government. As a result, the parliament thought it appropriate and brought an amendment by incorporating that is
for a period of 5 years.
Second proviso, that is cut-off date, that 31st March 2019. 4 years was again extended. Your lordship, provided further that every teacher appointed or in position, my lord, kindly have glance, as on the order on subsection 1, shall acquire such minimum qualification within a period of 4 years from the date of commencement of the right.
It is 31/3/2019.
My lord, this is my humble. Here what has happened, the provision which my Lord Senior drawn to your lordship attention, that was incorporated, my lord, after
this
cut-off date. After cut-off date, by way of an amendment of 2019, that your lordship will find that is there, my lord, after cut-off date, that is 9/4/2019. By way of gazette, that is substituted GO number 716 of 9/4/2019. But my humble submission before lordship, relying upon the divine judgment, but the 309 may I read, my lord. But at the first 309(1) says, subject to the provisions of the Constitution, Act, and appropriate legislature may regulate so and so, so and so, so and so. But provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union and for the governor of the state, or such person as he may direct in case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and conditions of service of persons appointed to such services and posts until provision in that behalf is made by or under any act of the appropriate legislature under this article. And my lord, this is important. Any rules so made shall have effect subject to the provisions of any such act. My lord, this is
you have to leave. You should have full stop, comma, semicolon, so that that will process.
Okay, my lord. Here, the second proviso also empowers government to frame the rules. That is always subject to the any provision, act or rules is being framed by the parliament or the legislature. But my humble submission before Lordship is, which was the issue in A.V. Krishnan, that if central legislature or the state legislature who has the field under the constitution to frame the law under Article 245 and 246, once they framed that occupied the field, the power of the governor is displaced. Therefore, this order being passed after commencement of this amendment, RCFC Act, and RCFC rule I have not brought to your Lordship's notice, I will bring, that has been more clarified. It is the state government to make a request, cannot relax. Such a power of give relaxation is not available. How could you give an exemption?
With the center.
With the state has no, with the center, but request will be made to the center. Center language is, your Lordship will kindly appreciate the rule.
This rule, which Mr. Swain is pressing into service, is made by the state government under the provisions of Orissa Education Act.
No. Under Article 309 provides you. Entire rule was framed also. And the virus of that very provision just coming to is under how the virus is not required to be relevant in this.
No state, etc.
No
state. There is no state to this matter also either.
But
tendency is no.
But there is a coordinate bench judgment against that.
Coming to
against that writ appeal is pending. There is a judgment of this Hon'Ble Court.
Holding.
My lord, holding therein that the teachers were appointed prior to the cut-off date.
Whether this aspect is considered.
My lord, yes, your lordship may kindly see that judgment.
No, I'm asking you.
RCFC Act.
Whether this important aspect is considered in that judgment.
That so far as RT Act is concerned,
not considered.
That has not yet been considered. But one thing, my lord, before my lord, your lordship may kindly see one thing. Yes, let me come.
I am comfortable.
Yes. My lord, so far as the Right to Education Act is concerned, Section 23 of the Right to Education Act, my lord, which came into force on 1/4/2010,
is amended.
Well, that was amended, and so far as that provision is concerned, well, relaxation was given for 5 years. That is for 4 years, 15 to 2019. Under the RT Act, more particularly Section 23, the prescribed authority is the NCT. Your lordship may kindly see academic authority. My lord may kindly see the RCT Act.
23(1).
Get the pace. Sorry?
What your friend says is...
Yes, I am coming to that. Well, I will explain.
Parliament enacts.
Yes.
The provisos.
In case of overlapping, my lord, I am conscious of
not only overlapping.
Yes.
It's not only case of overlapping it is.
In case of any conflict also.
Over.
Yes. My lord, I am conscious of that. Your lordship may kindly see one thing. My lord may kindly see Section 23. Page 180. In 180.
Section 23 of?
23 RCF Act.
Right to education.
That is in that manual also.
Yes, 23 I am holding.
23(1).
23(1).
Any person possessing such minimum qualification.
Yes.
Down by the academic authority.
Any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. My lord, then your lordship may kindly see, I have prepared what was the qualification prescribed by the academic authority.
Which authority?
That is NCT. My lord may kindly see this.
The National Council for Teacher Education.
Yes.
Sir, share a copy with them also.
Yes,
so that they will be able to have that.
Yes.
Is 31.
My lord may kindly
33,
31.
NCT Act. Notification issued by the NCT. My lord, your lordship may kindly see the first paragraph. In exercise of powers conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009, and in pursuance of notification number such and such dated 31st March 2010, issued by the Department of School Education and Literacy, Ministry of Human Resources Development, Government of India, the National Council for Teacher Education NCT hereby lays down the following minimum qualification for a person to be eligible
For appointment.
for appointment. Your Lordship may kindly come.
Whether appointment linked to the promotion also.
Yes, sir.
My Lord, subsequently,
Judgment 1 November 2025.
All right.
All the provisions that has been interpreted, answer is very clear of the Supreme Court judgment. We should save the time of the court if there is been no answer to the judgment.
What is this?
My Lord will find there is a clear declaration. The TET qualification is mandatory and nobody having the qualification.
Let me complete.
Considered.
Let me complete.
21A following this. That has come with the brief, madam. That is,
Your Lordship may permit me, I will explain everything. I will explain everything.
Sir, we can save the time of the court.
I will explain everything. Please allow me.
Listen, not necessary. Para court that has been dealt with. Your Lordship will find out. Your Lordship will find
this. Let me submit.
That is act flag.
He is not permitting me to argue.
Judgment is
He is not permitting me to argue.
Let them show.
My Lord, I will go to the question of promotion. Subsequently, Your Lordship may kindly see the NCT notification first.
No.
Well, this is the minimum qualification. Your Lordship may kindly see.
I want to. What is meant by the word appointment in section 23(1)?
Section 23(1).
Does it include promotion also or
no?
Therefore, I am asking you.
Yes.
Now, your case is not 23(1).
Yes.
Your case is promotion.
Well, promotion that has also been taken note of, that has also been taken care of in the NCT Regulation 2014. Your Lordship may kindly see NCT Regulation 2014. First, I will take your Lordships to the notification dated 2010. Thereafter, I will take your Lordships to 2014. My Lord may kindly, this is the Hindi version. Your Lordship may kindly come to page 5. Sorry, page 5. Page 31. These are the qualification for class 1 to 5. In addition, for appointment, in addition to that, my Lord, Your Lordship may kindly see and pass in the teacher eligibility test, TET to be conducted by the appropriate government in accordance with the guidelines framed by the NCT for the purpose. Well, the controversy revolves around it regarding passing of TET. So far as minimum qualification is concerned, everybody poses that since point is prior to that cut-off date 1 to 2011, we say that for our cases, TET is not necessary for promotion. How? Well, how, my Lord, I will explain. Here, Your Lordship may kindly come to clause 4.
Clause 4.
Clause 4. Teacher appointed before the date of notification. The notification date is 23/8/2010. I'll kindly note down.
Teacher appointed before the date.
Before the date of notification.
This notification is issued on which date?
23/8/2010.
23/8/2010.
Yes. The following categories of teachers appointed for classes 1 to 8 prior to the date of notification did not acquire the minimum qualification specified in para 1 above. But now Your Lordship may kindly come to para 1. Page 31. Page 31. My Lord, in that minimum qualification, that TET is there. My Lord, got it.
One above.
Page 31.
Page 31.
With the heading of minimum qualification.
Minimum qualification, that is para 1. That is from classes 1 to 5 and thereafter classes 6 to 8. Because the elementary schools has been defined under the RTA Act, that is 1 to 8.
And pass in TET.
Pass in TET. Controversy
by appropriate government in
yes.
accordance with the guidelines.
So that is exempted in view of para 4.
This itself is exempted. They need not have what is specified in para
1.
Minimum
qualification.
Other qualifications.
And so far as accepting to TET, we have got all other qualification, academic qualification. TET is a teacher eligibility test.
That is for appointment.
Then you will also kindly come to clause 5. Clause 5. Teachers appointed after the date of notification in certain cases, where an appropriate government or local...
What Apex Court said, what is meant by appointment? Whether it includes only direct recruitment and promotion also. Because there are some sections which say appointment by way of promotion. Just look at Apex Court said about that, na?
Yes. Well, then you will also kindly come to para 5. Teachers appointed after the date of this notification in certain cases, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with the NCT determination of minimum qualification for recruitment of teachers in schools, Regulations 2001. Well, Regulation 2001 is there in the next page. Here, my lord, that there is no TET. My lord, your lordship may kindly come to the next page for elementary, this academic qualification.
How can NCT say about this when the parliament is saying you should have this clarification?
My lord,
This qualification came in the year 2010.
But 2010, 2001 was there.
Yes, TET was introduced in the year 2011.
2011, 1 to 2011. My lord, I am coming to that. Your lordship may kindly see. Because of that, that is the cut-off date. My lord, may kindly come to page notification OTT notification. It is 40. Your lordship may kindly see. For the first time, well, at 11th February 2011, 11th February 2011, the NCT issued a notification to all secretaries, commissioners of education of state government, union territories, subject guidelines for conducting teacher eligibility test and the right of children to free and compulsory education act RT 2009.
Yes.
In accordance with the provisions of subsection 1 of section 23 of the RT Act, the National Council for Teacher Education had filed notification dated 23rd August 2010, which I have shown to your lordships, laid down the minimum qualification for a person to be eligible for appointment as a teacher in classes 1 to 8. It had been inter alia provided that one of the essential qualification for a person to be eligible for appointment as a teacher in any of the schools referred to in clause N of section 2 of RT Act is that he/C should pass the teacher eligibility test, which will be conducted by the appropriate government in accordance with the guidelines framed by the NCT. So this is the cut-off date, 11th February 2011.
No, that was, but this amendment is made.
Yes.
Long thereafter.
Amendment was made
by this
in 2000
Parliament.
Yes.
2015.
It came into force with effect from 2015.
That's what.
2015.
Though it is effected in 2017.
But so far as 11th February 2011, that is the cut-off date. Because
this cut-off date will now pale into insignificance because of parliamentary legislation. Parliament should save this.
Yes, but I will explain. Then your Lordship may kindly see, this is the notification.
Correct. There is march of law by legislative process.
From a retrospective date. From a retrospective date. Your Lordship, this is correct. But I understand that point. Thereafter, your Lordship may kindly come to the next page. The guideline was framed for teacher eligibility test. But who will be eligible? Your Lordship may kindly see clause 5. The following persons shall be eligible for appearing in the TET. A person who has acquired the academic and professional qualification specified in the NCT notification dated 23rd August 2010. A person who is pursuing any of the teacher education courses specified in NCT notification dated 23rd August 2010. The eligibility conditions for appearing in TET may be relaxed in respect of a state union territory, which is granted relaxation under subsection 2 of section 23 of the RT Act.
Yeah.
The relaxation will be specified.
Relaxation granted.
Well, initially, relaxation was granted for a period of 5 years.
4 years.
Subsequently,
4 years.
4 years, sorry, 3 years. Subsequently, it was amended. And
that means no relaxation thereafter.
Yes. Further 4 years was given up to 2019, 15 to 2000.
Correct. 31/3/2019.
Yes. But thereafter, so far as the state of Odisha is concerned, your Lordship may kindly see, TET for the first time was introduced in 2012.
Can I see section 23 again? 1 second.
Yes. I can't say that.
Who can relax under 23(2)?
Yes.
Relaxation has to be granted by the central government.
Central government.
No, NCT will give relaxation.
No, NCT will not give relaxation.
The relaxation which you are reading.
Yes. It is to be given by the central government. This is correct.
At least after the amendment.
Yes.
The central government has
Central government. Well,
relax the central government has to give by notification.
By notification.
Central government is defined.
Yes.
Under the General Clauses Act.
General Clauses Act.
Yes.
Yes. Well, your Lordship may kindly page
NCT is not central government. Because NCT is also defined.
Your Lordship,
the Teacher Training Education Act.
For the first time, your Lordship may kindly see, so far as Odisha is concerned, TET was introduced in 2012.
Correct.
So all teachers who were appointed after 2012, they are having TET qualification.
Correct.
But prior to 1 to 2011, those who were appointed,
they did not need.
They did not have. They did not have.
To have it, and therefore they did not have. You are appointed already. But after the amendment of this section,
yes,
where do you stand? Where is the case for
yes, yes. Well, now the question is, your Lordship may kindly see regarding promotion, because the main question is promotion. Nobody is questioning the appointment. Here, my lord, we are concerned with promotion from level 5A to level 5B. My lord, as per NCT notification 2014, NCT regulation 2014, the promotion within the elementary cadre, that will never be treated as promotion because it provides different levels. Your Lordship may kindly see.
What is meant by promotion?
Yes, my lord may kindly come to that. Page 71. The first page.
Who should treat promotion? Who should treat it as promotion, not promotion?
Yes.
Appointment. Who?
Well, that NCT has given.
Oh, NCT may say 100 odd things.
Because NCT is the academic authority.
That makes no sense.
Under section 23 of the RT Act.
It can say for direct recruitment, this for promotion, this for demotion, this for reversion, this for deputation, this
because the
repatriation.
Because the academic authority has to prescribe the qualification as per section 23 of the Act.
The question is not the 23(1).
Yes,
23(1) is NCT.
Yes, NCT.
Of course, that is read into 2 also.
Yes. Yes.
But after this amendment happened,
yes,
The parliament itself said that it should be like this.
Yes, yes.
And where do you satisfy?
No, my lord, so far as promotion is concerned, my lord, because we are concerned with promotion.
Correct.
So far as qualification is concerned, Parliament has already said. Now, your lordship may kindly see 2014 regulation of 2000 NCT. That is at page
Which judgment said?
Page 66.
Appointment includes promotion also.
Page 66. Ticket, home service.
O.P. Singla.
Yes.
The Supreme Court says appointment means directly includes promotion and promotion also.
Promotion
Therefore, 23(2) will apply to promotion also.
Yes, yes. Well, promotion, so far as promotion is concerned, that has been dealt with in the NCT regulation 2014, which is the academic authority. My lord, may I kindly see that. NCT regulation 12th November 2014. 66. And this was also, my lord, page 70. Page 70. In exercise of the powers conferred under clause DD of subsection 2 of section 32, read with section 12A of the National Council for Teacher Education Act 1993, and in supersession of the National Council for Teacher Education, determination of minimum qualification for recruitment of teachers in the schools regulation 2001, except as respect things done or omitted to be done before such supersession, the council hereby makes the following regulations. My lord, now your lordship may kindly come
for promotion.
Word promotion. That is para 4. Regulation 4. Clause 4. The qualification for recruitment of teachers in any recognized school imparting pre-primary, primary, upper primary, secondary, senior secondary, or intermediate schools or colleges imparting senior secondary education shall be as given in the first and second schedule annexed to
not
this.
applicable to you.
Then B. For promotion of teachers, the relevant minimum qualification as specified in the first and second schedules are applicable for consideration from one level to the next level. You will also make a kind mark it. And the level has been mentioned in the first schedule,
which includes 5 to 5A.
But 1 to
yours is from 5 to 5A to 5B.
No, our is 3. 3. Primary and upper primary for classes 1 to 8.
72.
And qualification, what is the qualification prescribed? Minimum qualification as laid down by the Council for Teacher Education by its notification dated 23/8/2010 as amended from time to time, issued in exercise of the powers conferred under subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009. Well, promotion means if one goes from one level to another level of this level,
left
hand side column. That means first is preschool nursery for children in the age group of 4 to 6 years. Second level is preschool nursery followed by first 2 years in a formal school. 3. Primary and upper primary for classes 1 to 7. Then 4 is secondary high school for classes 9 to 10. And next page you will may kindly see. Then 5 is senior secondary intermediate for classes 11 to 12. And here, if any promotion is made in the shape of appointment or whatever it may be, within level 3, then passing of TT is not necessary, according to me, in view of the notification dated 23/8/2010. Because there is an exemption clause that the persons who are appointed prior to 11 to 2011, that is the cut-off date when TT was introduced, they are protected.
Yeah.
And now your lordship may kindly come to the bill, the objective when 2017 amendment came,
56.
page 56.
56.
That legislative note your lordship may kindly see.
Page 56.
Well, your lordship may kindly see 57. Well, your lordship may, the right of children to free and compulsory education RT Act 2009 became effective with effect from 1st April 2010. It envisages free and compulsory elementary education to every child in the age group of 6 to 14 years. The proviso to section 23(2) of the Act specifies that all teachers at elementary level who at the commencement of this Act did not possess the minimum qualification as laid down in subsection 1 of the said section under RT Act need to acquire this qualification within a period of 5 years from the date of commencement of the Act, that is 31st March 2015. After completion of the said period, yes, after completion of the said period, the state governments have not been able to continue the training process for in-service untrained teachers. Hence, the state government have requested for extension of the period for training untrained teachers so as to enable them to initiate and complete the said training process. My lord, as reported by several state governments, out of total 66.41 lakh teachers at the elementary level, over 11 lakh are still untrained. Of this, about 5.12 lakh belong to government and aided schools and about 6 lakh to private schools. State-wise number of untrained.
Prelude to that amendment.
And thereafter, well, a letter is. Yes. The present bill, the last paragraph, the present bill seeks to insert a new proviso to subsection 2 of section 23 of the said Act so as to provide that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 of the said section shall acquire such minimum qualification within a period of 4 years on and from the date of commencement of the proposed legislation. So basically, the objective of the Act or the bill, which says that the teachers who are untrained, it is not meant for teacher eligibility test. Teacher eligibility test is an examination. So far as primary school teachers, the primary school has been defined under section 2N from class 1 to class 8 in the RT Act. Either one must be +2 CT or BA B.Ed. So training is either CT or B.Ed, not TET. TET is a formal test, that is teacher eligibility test to compete in the examination. So that is the objective of the bill. Then you will also kindly see.
No, we need not look into the objectives of the bill because
the Act has been passed.
Act has been passed.
Yes, sir.
There is only heroics.
Yes.
And the American judgments also, which we have followed. While interpreting the provisions of Act, the court shall not go to the etymology of the legislation unless there is the incoherence or object is not clear, or if there is any ambiguity, the legislation need not be. We should not look into what all factors. When we go to take bath in Ganga, we need not go to Gangotri itself. As long as
to find out the origin.
Yes, that's all. Unless you doubt the water that has come here is Ganga or not, only then you can go to Gangotri, Gomukh, these things. That's how English law, constitutional law, rules of interpretation. The Apex Court said, in his constitutional law, 4th edition. Well, the court will not go to
all these things
at all.
So later,
can we come after eating our lunch.
Actually, I am not prepared. I thought that your lordships will defer this matter, awaiting the judgment of awaiting the
He wants a short
judgment of the division bench.
and he's a very respectable member of Parliament because never
Your lordship may grant me some time so that I will be
so that you
get fully prepared.
bring your notes.
Yes.
So that I will decide it once for all.
Yes.
We are going to have this matter.
One thing I can. First point, whether appointment, promotion. That has been dealt with in
adjournment.
But the Supreme Court judgment has dealt with. Then
Adjournment.
Exemption also dealt with. Specific. I am not going to that. But all the points has been dealt with.
I am not fully prepared. Your lordship may grant me.
Whenever he said
Yes, we have sought and we have also filed it. It has come in H. Annex, as flag H. It is with the brief. Yes,
generally, Spain comes with lot of preparation. When he says, I have not prepared, I have to give time.
I am not standing at the granting the opportunity, but a short date maybe because the promotion has been stalled for the state intern. And at the instance of an unqualified person, single unqualified person.
Do you have the petition where challenge is laid to the...
Yes, I have challenged. I will from the petitioner's counsel, lead case is mine. I can also provide
you that one, so that I will read. So I will have larger view of the matter. Yes, that will be good. Which date, Mr. Sven, you want to?
December 2nd week.
Second. That day you are.
Yes, I will.
Seek
Yes.
Well, no, even if he says earlier, I cannot post because my calendar is full now. So I wanted him to say third week, but unfortunately he said second week, some date is fixed at date. In second week, accommodate it on a particular day.
May I table a date it be parted and 2 p.m. so that it can reach or earlier, as your lordship pleases. So that matter can be ended.
2 p.m. Parted, I will not wait.
Yes, because
your lordship may fix it to 12th. 9th I have some.
12th.
Yes.
So that if you complete the argument that day, 13th, 14th, I will 2 days so that I can work and pass the order itself.
Yes, yes.
All right.
Interim order to continue.
2 p.m.
2 p.m.
Interim order to continue.
But you have raised a very new point. In fact, I was against the vacating or taking decision as of now. Since you raised a new point, the other judge has not considered that aspect of the matter at all.
Yes,
and that judgment has been challenged at the instance of the state government.
Even otherwise, assuming that the state government fails in the judgment. Now, since it has not referred to the other aspects, because it was argued also.
But everything has been taken care of by this Hon'Ble Apex Court.
Yes,
and it has set at rest, my lord.
That will go through.
Yes.
Yes.
Lots of items.
Interim order to continue.
Interim order.
Lots of items 62 taken up some other date.
62.
68 lots.
68.
Lots.
Anybody moved that matter or we have come on?
Lots of my senior was supposed to argue this matter today. But
first week of January.
Lots of.
Have you informed the other side?
Lots.
Lord, a short date be given, please.
Short date. First week of December. Anyway, first week of December.
First week of
mid-December.
The first week of January will.
No, my lord, it's related to gold medalist student. First week of December.
10th of
I may be similar. On the next item, item 40, but there is a noting that a memo has been filed for withdrawal of the writ petition. But I am the only counsel therein, but I have not filed any memo and I have no instruction that whether the memo has been filed by whom instance, my lord.
Share that memo.
That is in form K, flag K.
Anyway, if he wants to withdraw the memo, I have to.
I am not, my lord. I have not filed. So even if
of withdrawing also will not.
My lord. So I
sometimes might have been wrongly placed. So that let it be checked.
Just look into that. Okay. Memo is there. There, but whether it is signed by, or even if you want, see that whether he has filed, why he will file withdrawal when after filing the writ petition. So just looking. Let us.
Correct. But Tahsildar not receiving our money and rent receipt till today, my lord.
Just instructive.
Yes, my lord.
He has to abide with the order. Na?
Yes.
Otherwise, I will haul up him for contempt.
Yes.
When it is time bound,
Lordship.
ask him to speak to the Tahsildar right now.
Kali meeting. So yesterday I had the information. They have both the groups. They have some meetings, but the meeting was failed.
What meeting? No order. Implement the order.
My lord.
That's all.
Tahsildar total denied, man. I am not receiving.
He said not receiving.
Yes, not receiving the money.
Of that.
Some of the would things also. They are
No. Merely saying it will not.
That is
If he is refusing,
just within 1 hour, you report to him what he has done. You tell him that he will face some difficulty. I will direct his arrest and detention. If he refuses to receive the order when the lawyer is giving what he thinks of himself, this is going by his version.
My lord, let me
warn him.
understand.
Warn him. I may summon him. I may direct his arrest and detention.
I beg pardon.
Abide by the order.
I beg pardon, like you mentioned item 63, covered by the original judgment. I'm giving the copy to
Which item?
63. Referring Ajay Kumar Chaudhary's case.
Mr. G warned that Tahsildar. Threaten him. He should abide by the court order. What he thinks.
Referring Ajay Chaudhary's case, that order has been passed.
No, sir.
So that's why they are delaying.
No. Court has told give me 1 hour.
Very assured. This entire compromise is brought about because of involvement of Mr. G. How can the Tahsildar say, what does the Tahsildar think? He is simply a servant of the people. Covered by judgment.
Yes, my lord. I am giving the copy. Referring Ajay Chaudhary case, my lord. I am placed under suspension 2020. But in that case, he was placed under 22.
But say, kindly reach. Let the matter.
Please mention when it reaches. Yeah.
Yes. My person, the other side has gone also.
Yes.
Really stating, I had received the instructions, but there were some stumbling blocks for me while settling the counter. So I have asked for clarification. Your Lordship may call it next Friday.
Next Friday, too long time. Let's see. 1 month had already passed.
Thursday will come, or Wednesday will come. Wednesday.
I have to put something thanks to us today can process it. Offline,
that can be done. That can be done once your Lordship directs.
We make the order. They can't say no. Offline, online. Wednesday at the request.
Item 56, your Lordship, direct to take up by 2 o'clock.
Mr. 6,
56.
6, 8 to be taken up. Yeah, because all the way.
Pardon to make reference out of that. Item 44 on the board today.
44,
my lords. The pleadings are complete. So it will take substantial time. My lords, my only request is to be fixed on 25th or 26th. Taken consent of my learned senior.
Your friends are agreeable with that proposal? Agreeable? Yes, sir. Yeah. Can we have it in the second week of December?
Interim order.
No problem. Interim order will continue. You have interim order now?
Yes.
Then why urgency? Let the heard man. We will hear you, no problem. But in the first week of January, because I will protect you by interim order.
Your Lordship, December 2nd week. As suggested by your Lordship, December 2nd week.
Interim order is to interim order to continue. First week of January. Yeah. Yes, next. That record confirm. Record your Lordship confirm. Which record? Is this Lordship? This matter. In this matter, yes. No, who should secure the record? Say Jagannath case matter. How can I call? Now matter is not come before me at all.
I have already filed the IM.
You have filed the IAS? The IAS has come up? Yes.
It's not numbered yet. It has been not numbered.
Ask the registry to number it within 10 minutes. It should come here within 10 minutes. Sir. Yes.
Item number 56, sir.
Sir.
Lordship. Before addressing your Lordship, with your Lordship's permission, I may take 1 or 2 minutes for your Lordship's appreciation. Here is a case. My prayer before your Lordship is to quash the order of recovery which has been made from the petitioner, who is a class 3 employee. And the second one, the amount which has been deposited from my salary in the GPF, that also is lying with them since 10 years. The case is like this, Your Lordship, for Your Lordship's appreciation. In 2000,
when he retired, sir?
Retired 16th June 2016. Always 30th June.
30th June.
Second third. Suppose say June. 30th June 2016. The fact is like this, Your Lordship. In 1990, joined in the class 3 service as an assistant teacher under the district education officer, Jagatsinghpur district. That there she continued up to 2009, Your Lordship. Then from March 2009 till her superannuation in 30th June 2016, she was transferred, brought to the control of district education officer, Cuttack, for that period of 7 years. After her superannuation, she was served with a letter by the DO Cuttack that you have a credit of 287 days and you are entitled to get the gratuity for that 287 days.
Yeah.
Thereafter, the bill was submitted. Advice was made to the Treasury. Your Lordship may have a glance to Annexure 8.
The 8.
Yeah, Annexure 8. At the running pay 36.
Payment of cash equivalent to leave salary. 287 days. You are right.
287 days.
Yes.
But while the payment was made by the controller of accounts, the next annexure, Annexure 9, Your Lordship.
This is not included.
No. Says that has been deducted. Annexure 9, Your Lordship, next page, 39. 2,38,474 has been deducted. I went to the controller of accounts. Thereafter to the DO, they told that the excess payment has been made. What is that excess payment? No payment has been made. Even assuming for the sake of argument, I submitted to Your Lordship that the excess payment has been made to a class 3 employee.
Cannot be recovered at all.
Cannot be recovered. That is the Rapid Moses case, Your Lordship. But at the court of to refresh Your Lordship's memory,
Justice K.R. Singh judgment.
Honorable Justice Arun, exactly, Your Lordship. That is the only thing. Number one. I want to bank upon the case of that Rapid Messiah, that even if assuming for the sake of argument,
still you cannot recover.
That cannot be recovered. You cannot deduct this amount.
But
number one.
Other point.
Number two, so far the deposit on GPF is concerned, they have made some payments, but the some are lying with the controller of accounts, and that is not yet been paid since 10 years. Those are the two things I have wrote. So that Annexure 9 to be quashed, directing for payment of that amount of 2,38,000, which they have illegally, arbitrarily deducted.
But you have not prayed for that.
I have prayed for. That is my prayer, Your Lordship, exactly.
I will take your lordship to my prayer.
Yeah. You have sought for only mandamus. That's
To
all.
quote that annexure 9, the next page, your lordship. Page 8.
You are right.
And to pay 2,38,000. That I have prayed. I am conscious of it.
You will ask them what.
Your lordship.
Yes, sir, Mr.
With all interest they should pay because it is there.
Mr. G, on what?
I had an instruction from the department. They said the DEO Cuttack had sent me an instruction saying that due to modification of pay and excess amount arose thereof, which was calculated and stated above, was recovered from the admissible DCRG of the pensioner as reflected in the DCRG under Annexure 9. Further, it is to state that the pensioner has submitted an undertaking declaration under OCS pension form at 5A to the effect that if any overpayment made to her is detected while in service or after retirement in respect of GPF account or on account of gratuity, pension, TI, on pension,
She has undertaken to give back.
To give back.
But
back,
where is
my lord.
the adjudication?
My lord.
She has been taken. She has taken.
My lord, what is the objection was? My lord.
That is done in every case. Class 4,
My lord, as per objection.
That is the undertaking.
Objection raised by the Controller of Accounts, Odisha, Bhubaneswar. The modification of pay was recasted by DEO Cuttack by the order number dated 17/3/2017. Due to the modification, revision of pay, excess amount of the pensioner was calculated from 1/1/2013 till date. The Controller of Accounts, while examining the service book pension paper, raised the objection about entitlement of RSCP in favor of the pensioner. Accordingly, it was instructed to DEO Cuttack by letter number so-and-so to regularize the pay particulars of the petitioner with effect from 1/1/2013 under attestation of pension sanctioning authority. Excess amount paid, if any, in this regard.
No, again, assuming that it is excess amount.
Yes.
His first contention is Rafiq Masi.
Rafiq Masi is there. So government money, my lord, the excess payment.
Rafiq Masi applies in government money only.
Yes, my lord. No, government money that
Rafiq Masi applies only when government money is wrongly taken by the employee.
There are 300 cases have been clocked up only one. Rafiq Masi case.
Krishna had structured the prayer as that. Kindly be seated. Learned counsel appearing for the petitioner urged two grounds for invalidation of the action taken. Namely, in view of apex petition in Rafiq Masi, even if excess amount has been paid, the same cannot be recovered for an employee of the cadre of the kind. Secondly, no opportunity of hearing has been given before judging that what has been paid to the petitioner is in excess of his entitlement. Therefore, there is violation of principles of justice. First. Next. Learned AGA Mr. G appearing for the passionately resists the petition, contending that what has been paid to the petitioner is far in excess of his entitlement, and that at the time of sanctioning and releasing the pension, he had given an undertaking to reimburse whatever has been received by him in excess. 7. Therefore, petitioner is stopped from making the claim of the kind by invoking the writ jurisdiction. First, G also drew attention of the court to the district collector's, is it district collector?
District education
officer. Endorsement dated?
My lord.
Fine. Next one, having heard learned counsel for the party and having perused the petition.
No, dated 21/4/2025.
This court is inclined to grant indulgence in the matter, broadly agreeing with the first submission that petitioner being in class 3, group 3, at the time of demitting office on attaining the age of superannuation, whatever arguable excess payment made cannot be recovered from him, he being in the evening of his life, post-superannuation. First, this wave gains support from the decision of Apex Court in Rafiq Marsi, wherein paragraph into that particular that judgment. Do you have that judgment copy with
12. I have given paragraph 12. Lack but one paragraph.
I have considered this aspect of the matter in one.
Yes.
Do you remember any judgment?
No, I do not. There is another Odisha judgment also there, confirmed for the Supreme Court from Sahu, Jogesh Sahu.
Jogesh, same. The principle that has been laid down by Apex Court has been applied.
At paragraph 12 of the decision, the Apex Court has observed as random. Whether this one. First, next one. The second contention that no amount is payable to the payable by the petitioner to the OPs, and that despite giving such an undertaking for reimbursement, the law declared by the Apex Court in Rafiq Marsi cannot be diluted, need not be much examined by this court, since relief needs to be granted to the petitioner in terms of Rafiq Marsi. First, court has to write the judgment and not the thesis. Next one, in the above circumstances, this petition succeeds. A writ of certiorari issues quashing the order dated so and so issued by issued at Annexure 9, whereby a sum of rupees 2 lakhs, they go to play
38,000,
474 have been recovered. A writ of mandamus to which OP?
Controller of accounts.
Controller of accounts कौन करेगा? Disbursing authority कैसे देगा ना?
OP number
5.
No. OP number 2 and 5. 2 and 5.
No, 2 and 5.
OP numbers 2 and 5. 2,
3 and 5.
2, 3 and 5. To pay back the entire money deducted from the petitioner, deducted from the payables of the petitioner on retirement within a period of 8 weeks with the interest at the rate of 9%.
Whatever they
12% that is there, they have given.
Statutory interest, whatever it is there, they will get that.
For 2006, 2016.
6% melody lordship.
7%. 7% per annum. in the light of apex court decision in no, leave it, 12%. With effect from the date when the said amount ought to have been paid to the petitioner. First of all, if delay in refunding the amount and also paying the withheld DCRG is proved, the interest rate would stand substituted by 12% instead of 9 ab inceptio for the first 2 months and 18% for the months next following, for the period next following. Next for the interest component may be recovered from the erring officials in accordance with law.
And also the missing GPF, the second pair I have made, with the GPF which is lying with them, they are not paid.
Yeah, GPF, not
GPF also.
GPF.
The missing GPF.
Yes.
But they have paid the rest part that is lying with them. Controller of accounts.
Yes.
My Lord, may I subject to Lordship's acceptance that OP number 3 has no role to play because I was earlier there before DO Jagatsinghpur. In 2009, the DO Katak is the officer.
Which DO?
DO Katak and the controller of accounts. OP number 2 and 5 only.
2
not 3. Problem.
Yeah.
Urgent copy.
They only will get a copy. Yeah. Some copy to be added.
Item 33.
Yes, sister.
The petitioner had appeared for AIA PG ET exam, my lord, 2025. It's a post-graduation entrance test, my lord. Post-graduation entrance test she had appeared, and she was selected in the round.
Those who use the mic properly, for them 25 grace marks.
In round 1 of the counseling, my lord, she was selected in Puri, my lord, the Gopavandhu Ayurveda Puri. She was selected there, and then she kept the seat floating for further upgradation. In round 3 of the counseling process, she was upgraded.
OPS for the OPs.
It is not OPSC, it is a 2 organizations there. One is NTA OP number 3.
National Testing Agency.
First time it is coming up.
First time.
You should notice.
My lord, there is one predicament, my lord. In round 3 of the counseling process, I was selected in Haryana, my lord. However, I do not wish to take admission there for certain reasons. They are asking me to sign a bond of 7.5 lakh rupees. Further, there are no hostels. And the emolument, the fee that I am supposed to pay, that has been enhanced to 82,000 from 22,000. For these reasons, I did not want to join the college. My lord, they have cancelled my allotted seat at Puri, which I had gotten in round 1.
Puri seat was allotted.
I'm just clarifying. It's a all India test examination. OP number 2 is the organization. They are monitoring the entire all India system organization. Suppose a student has got a particular seat, he or she cannot block another seat. What they want, because we have taken a seat from in Puri, we also apply for the Haryana. If you have got there, then the seat may be blocked. It will not permission. And second,
Puri seat, she is entitled.
Yes, she is entitled. But she cannot claim that this seat should be blocked for me and I will go Haryana. If I have got there, then seat should be vacated. Then
my lord, I do not want to take admission in Haryana. I
do want.
No, my lord,
we also don't want.
No, Puri we want.
Puri we want. Puri we want. However, in Haryana, we did not take admission. We were allotted a seat in the round 3 counseling process, but we did not want admission there for certain reasons. Thereafter,
You opted for Puri?
Yes, my lord. My lord, if...
Show the document.
My lord, in Annexure 3, there is a provisional admission. Lord, if I am not relieved from the round 3 counseling process, I cannot join back to Puri, my lord. And I am bound to join in the third round institution, my lord. If I do not join, my entire candidature for
the allotment of seat, that will be cancelled.
R3 acceptance counseling is
When the counseling is scheduled.
My lord, the council is already taking. Today is the deadline, my lord.
Or the birth in the Puri. As per my first
Just you take notice.
Lassima give issue notice.
That's all.
My lord, just one more submission. My lord, one more submission is that today is the deadline. If I do not intimate the authorities at Haryana that about my willingness or unwillingness to take admission.
So there is no bar to give it on that. I don't know.
The entire candidature will be cancelled, my lord.
He's saying yes and you're still arguing.
My lord, I'm filing an IA for reservation of seat. The seat at Puri may be reserved for me.
I think that you have got this seat in Puri.
My lord, we have got the seat in Puri. If we don't take admission in Haryana by today at 5 p.m., it will be cancelled. The entire candidature will be cancelled.
That I didn't have that.
That will be cancelled.
You have said it, no?
My lord.
You need not repeat. I am not that allowed to hear the repetitions. Issue number that notice. Alternately, yes, required accepts notice for
1 and 2.
1 and 2.
My land.
Your Lordship, voting for OP number 3, NTA.
Name.
Milan Kumar, Your Lordship.
Name. Panel consider here for OP number 3. AGA for 4. 4 and 6 also.
No, Your Lordship, only for 3.
Only 4.
Only 3.
6 is also an independent body.
State.
5 and 6.
No, my lord. IPG, UJE, there is a separate councils. And the principal also is independent body. State can open number 4 state can.
Issue emergent notice to 5 and 6. It is open to the petitioner to serve copy of the petition on the panel counsel who usually represents OJE board. First, petitioner is permitted to send an intimation to Haryana.
To Haryana, my lord.
Which is that institution?
Shri Krishna Ayurvedic Vidyalaya, my lord. Shri Krishna Ayurvedic College, Kurukshetra, Haryana.
You have to write down that way you have to give the test.
Pardon, my lord?
Slowly, he has to write down.
Shri Krishna Ayurvedic College, Kurukshetra, Haryana.
Haryana. That she is not opting for admission in the said institution. Since she desires to have admission at the institution at Puri.
Hari got the path. Hari got the chance to be admitted because he is selected in the group 1 in the Puri.
In the Puri.
That may be clarified.
Come on, really. She claims to have been allotted a seat.
One clarification is surprising problem. She should not be allowed to participate in the R3 process.
It hardly needs to be stated that in view of the stand.
Should not have participated paragraph base 6 paragraph K.
Petitioner as above. She need what you should say? She need not participate. No, she has
She should not participate in the R3.
Who participated?
No. There should be undertake that, then we will instruct accordingly. This should not be allowed.
Understand. Come on. Petitioner to undertake that she would not participate or seek benefit in the R3. Round 3 counseling. So that a seat in Puri Institute can be kept reserved. First.
Not urgent copy.
That's the thing. Lawyers are not supposed to repeat unless the judge is dull argument. I don't believe that I am much dull-headed.
No, that was
maybe that will be torture. Many times people repeat. It becomes difficult for me to tolerate the repetition. Yes. The torture.
Item 40.
Copy to be acted upon. Mr. DST, inform the concern that
Yes,
this
yes.
is the order we have telephonically.
Yes. Mr. Let them serve the one extra copy to us and also the.
Copy number 3, Your Lordship.
3 of
DST is directed to telephonically inform to the concerned quarters about this interim order right now.
Well, at item 40, although there is a memo filed for Utal, I have not filed that memo. I have also verified during the launch hour that some J. Patra signatory carries J. Patra, perhaps wrongly somebody has filed.
Counsel for the petitioner submits that he has not filed any memo for withdrawal of the petition. First, submission accepted, and the one filed by somebody is rejected. Therefore, writ petitions will be heard on merits for public matters. Next.
Item 41 has been adjourned. Item 42.
Item 42, may I please alert, sir? It's a case of regulation of the service of the applicant who is working as data entry operator before the opposite party number 2 since last 16 years, Your Lordship. It's a second round of litigation. Previously, the petitioner approached this honorable court. This honorable court directed to consider the representation and the representation.
He says no.
Yes.
Minute of the chief.
Yeah, earlier court was concerned in this matter. He was the conducting counsel. Therefore
it is our.
Yes.
What is the case about? What is your prayer?
Yes, my prayer is at page number. My prayer, 13. Page number 13, Your Lordship. To quash the order under Annexure 14 by holding the same as bad and illegal, and thereby direct the opposite party issue formal order of issue formal order in favor of the petitioner regulating the service of the services as data entry operator in the establishment under opposite party number 2 with effect from so and so respectively. That is the date of completion of 6 years of direct contractual service with usual allowances from time to time. As per the GA department
18/1/23 order.
Yes, earlier the petitioner had approached this honorable court. This honorable court directed to consider my representation, and now by the Annexure 4, page number 29. Annexure 4, order dated 18/1/14. Yes, Annexure 4.
Annexure 14.
Annexure 14, page number 39. Order dated 18/1/2023. They have rejected my claim for regulation on the ground stating that in absence of any sanctioned post, my appointment is illegal. First, and second, my lords, the lordship may kindly turn to page number 40, last paragraph.
First ground is
the above.
No post.
No post. They say they have.
That's what they are saying.
They are saying. Contrary to record.
The first one is no post.
No post.
You are appointed against no post. You are engaged against no post.
They are saying no post, but I am saying yes. They have admitted.
Not ask you over.
They are saying no post. Yes. No post.
Number two,
that that as on 10/4/2006, I have not completed 10 years. Therefore, Uma Devi is not applicable to me. Second, that is second row.
Uma Devi is applicable.
Yes.
Not it is applicable, not applicable. It is applicable because you have not completed 10 years, and therefore no relief can be granted in terms of Uma Devi. Hey, well, it can be seen there for both the ways.
Yes.
Understood.
Yes.
What is your answer to first point?
So far as the first point,
posts were not there.
That is my humble submission is that is contrary to the material available on record. Your lordship may kindly see page number 12. Annexure 12, page number 36.
36.
Yes, your lordship.
Post was there?
Yes.
Which paragraph?
Annexure 12, page number 36, first paragraph.
Slowly.
Yes, I'll read my notes.
Yeah.
Details of the details of any such data entry operator DO working in OJE against sanction state of two data entry operators, Sri Rasmiranjan Patnaik and Sri Rajiv Lochan Mahapatra, the petitioner, are the only two data entry operators working in OJEE office against sanction state of two data entry operators. There are no other contextual data entry operator working in OJEE office apart from them.
Whose letter it is to whom?
It is the yes.
You were appointed against the vacancies in the post.
Yes, Your Lordship. And also, I will take your lordships to page number.
You were appointed on which date?
Well, it's in the year 2009, Your Lordships. I have appointed my joining.
Shall you give the date?
Yes, Your Lordship. Appointed. Annexure 4 is the joining. I'm just.
Don't be tense. Be at your ease.
Yes.
Slowly you do.
I'm sure. That's 25, petitioner number 1, joined on 25/9/2009. And petitioner number 2, joined on 5/10/2009.
So posts are there.
Posts are there. And also,
the second one, they said that is not completed them here.
10 years.
What is your answer to that?
My answer to that is, so far that regulation, as on date, I have completed more than 10 years. I was appointed pursuant to an advertisement.
Advertisement dated?
Advertisement at Annexure 1, Your Lordships. I'll just. Yesterday, while preparing this case, I have made a handwritten note.
You made it?
I have typed it for Your Lordships.
Yes. Appointed pursuant to an advertisement dated?
It's Annexure
10/9/2009.
Yes, Your Lordships.
Selection committee conducted it.
Annexure 2.
What is the resolution, brother?
Mallet's resolution at
Annexure 7.
Annexure
7.
Yes, Your Lordship.
What it says?
What is, yes. I'll take Your Lordship to Annexure 7, Your Lordship. That says that I'm claiming my regulation in this, basing on this resolution.
What it says?
It says, can I take Your Lordship to page number 25, Your Lordship?
Yeah.
That the person appointed on a contractual basis, after completion of 6 years, they are deemed to be regularized. Basing on this resolution, Your Lordship are allowed for cases in which 14 years. I'll give that. But this is completely identical, Your Lordship. And yesterday, we have won a case before the Honorable Supreme Court wherein 600 data entry operators will be regularized. That was our case, Your Lordship. This order is Your Lordship's order. It's fine. Squarely covered by that order, my Lordship.
Yes, I remember.
Yes, Your Lordship. I have a written note of submission. I'll just hand over.
Yes, Mr. Monty, what did he say? So much research and
yes,
he argued very well, except that he was very anxious, that you should not have.
I'm sorry.
No,
Here, my lord,
not be anxious, because when one is anxious, the heart, lung, and kidneys, they work 3-4 times more than what they usually work. That affects the system. Why should you be tense? I am not an elephant or some wild animal. I am also like you. I am sitting here. You are privileged. With privilege, you are standing there. I cannot run away even if Cobra comes here. But definitely run away.
I'm putting my best for us so that I can get the order. Which is
very well. Appreciate. You should not have the tension, etc. Not good for him.
Here, my lord, the contesting parties, OP number 2, the Odisha JE.
Who is represented? Who represents?
They are independent.
Whether notice was served on them?
And notice served, they have also filed the counter.
Then we will kind of go ahead. We cannot wait for the lawyer to come here. Court is like Jagannath Rath. It goes. Take down.
So far this annexer 2 is concerned, Milo. So far the offering letter is concerned at annexer 3. That is also issued by the JE. And so far the advertisement is concerned, also it has been issued by the chairman Odisha JE. And the offering letter is concerned, this is also given by the OP number 2, Milo.
OP number 2.
May I make a request here, Lordship? Here, Lordship, kindly turn to annexure 10 at page number 32. That is annexure 10 at page number 32. Opposite party number 2 has recommended my name to regularize. They say I have been continuing. And even if I have regularized, no financial burden will be on the state exchequer. They have written in details, Lordship.
Possibly, Melo. As the name is not reflecting, they may not be knowing, my lord. And the cost title.
Published name is not reflected.
No, Miller.
My lord, I am on behalf of OJE, on behalf of Mr. Subir Palit, Senior, our name has not reflected in the.
It is not reflecting in.
May kindly be allow 1 week, next week, Monday. More bless you.
Registered. Why they have not reflected the name?
Name may be reflected, it will be.
Ask who prepares the publish. Ask him. So much time I have wasted. And he has invested. Yeah. Monday, you should come without any tension.
Yes, that's
right. You do some pranayama. Tension will go away.
Out of the court, you will be free.
Rather, I will awake the internet on Sunday minutes. What will happen on Monday? Great failure, actually.
Do you remember there was a poem when we were in the school?
Everything shall pass over.
No, not that. This too will pass over. That's on the list. Solomon Grande, born on Monday, we had some fight. Like that's it itself. Friday, you have laid the foundation. Monday, something will happen. Great, hopefully, for the great people. Yeah, but I appreciate the way you argued. Very beautifully you argued. Great. Okay.
What is the problem? Sorry,
register to bring the name of. Yes.
Item 43.
Madam Amita Mishra on behalf of OJE.
Yes.
In item 43, my lord, we have already filed counter.
43.
My lord, they have filed a rejoinder, not served the copy.
Not served the copy.
Yes, sir, I have served it.
You one more.
Copy I have served it.
You one more. All right, we will give that copy if you do not want to give.
I have got
it and give it from our file.
I have got the receipt of filing.
All right, we will give from our copy now. All right, xerox it and give it. He's asking for one more cup of coffee.
I am behalf of a petitioner who is out of employment since last 5 years.
How many pages your counter, your rejoinder?
Yes, I have rejoinder is about 18 pages.
18 pages. So you give 18 pages.
Yes.
From our record. Okay? You get from our record.
Neither the available record and also in the LMS, my lord. have verified the elements.
Yes, you. Call in the first week, the second week of December 2021, the request of Lovely ASC, who wants to procure and look into the rejoinder filed by the petitioner. Since counsel for the petitioner others that he has already filed third copy and he may not be asked to give one more copy to him. The registry to furnish copy of our rejoinder to the ASC. Yes.
My lord, I may beg for a date particularly.
The second week of
second week, later date or 10th or like on 10th.
Item 45.
Yes, 45.
Item 45.
Counter affidavit not received. 45 also. 45.
And your lordship has also.
In 45 minutes I am here, copy not, counter of the counter copy not been solved.
Not served on no. Human cost.
Not in high.
But the counter received. Oh, it's right. Okay. Okay. You want to find counter or what?
If your lordship gives some time.
No, if you want, I'll give you. It's the 24 matter. But within 2 weeks, you file counter after serving copy on yes. 2 weeks for filing counter. Yeah.
Item 46.
46 suburbs
What pages?
both 46, 47.
46, 47. Both are covered.
Yes, ma'am.
Share a copy with your.
My lord, name of Mr. Dhanavapata may be reflected for the university, applicant for university.
Why three judgments? This therefore, this judgment is followed, na?
Item 48.
This is a matter related to RSC. The petitioner claims RSCP and on the basis of he has already completed more than 50 years and thereafter in the meantime the counter has been filed in page 4 para 7 of the counter affidavit they have already admitted we have already sanctioned the grade pay 4,200 on second financial upgradation on completion of 20 years service. But I have not received and they have also enclosed one document the sanction order. You also can see annexure C by 4 C by 4.
Page 13. Page 13. 1 3.
1 3.
Yes.
1. And only 2,800 they have sanctioned.
What should have been sanctioned to you?
I am entitled for 4,200 and they have already mentioned in para 7.
Para 7?
Para 7.
In the counter?
Para 7 of the counter.
Go to para 7 of the counter.
Page 4.
Page 4.
Last 4 lines from the bottom. In consonance with the said clarification, the petitioner was allowed to receive grade pay of rupees 4,200 at second.
But they are saying 4,200 only.
But I have not received. So that I have
verified that. How can that happen?
So lordship,
you have to give it.
Well, already they have admitted that they have already sanctioned me. I have not received.
No, therefore they have to ascertain when, how you have sanctioned it. And where is it reflected in the payslip?
Yes, annexure 4
It should be reflected in the payslip, na?
Yes.
Show that. Where is that? Where is your payslip? Last one, the last month payslip.
This pay fixation statement at C/4, there it is mentioned 2,800.
No, how can that be?
That I have to verify.
Just verify and come back.
Yes.
Short match.
Short.
11th of December, 18th of December. Yes.
Item 49.
May I please your lordship?
Yes.
My lord, this is the second round of litigation. The action of the university under Annexure 14 rejecting my claim for promotion under career advancement scheme is under challenge.
Who appears for the university?
Mr. D.K. Dan Mahapatra, Senior Counsel.
My lord, Senior is suffering from bereavement. My lord, his sister today morning passed away. So my lord, can it be taken?
My lord, let it come on 20th. My
First week of January 2020. Yes.
Item 50.
Date may be fixed.
First week.
First week of
January.
My lord, one thing, my lord, when this case was filed, when the petitioner was in service, but the university took several times for, and by that way, the petitioner has been retired, my lord. Now he is not getting his all his because the pay will be fixed. And
But actually he is drawing now.
My lord, December in any.
No, he is drawing pension now.
No pension, my lord. So December. Any date in December.
December 24.
24, I have some observation before 20. I have person, I have
23.
Before 22nd.
Item 50.
Yes.
May I please, Your Lordship? This matter relates to regulation of service. But all the petitioners.
I'll counter in this case.
You want to file the counter?
Yes.
Counter to be filed in 3 weeks. Yes.
Item 51.
Your Lordship, may fix it.
20, the first week of January. First week of January.
Item 51.
May please. Approval order to be modified. Pardon? Approval order needs to be modified.
Yes, madam. But we are in the receipt of the block grant. Actually,
Objection is filed.
counter they have filed.
Counter they have filed.
Rejoinder I have also filed. There are 2 judgments of the coordinate bench of this honorable court in this field. Madam. I have also stated in that in my rejoinder.
The first week of January. First week of January. Court has no time. Yes.
Item 52.
Here also the prayer is for passing of the gradation test and the consequential promotion in favor of OP number 4 and 5.
Why it should be questioned actually gradation list?
Because the gradation list has been prepared by topsy-turving the final gradation list, which has been continuing for the last 20 years and changing the belongingness of mine from one department to the another.
Who is your opponent?
If I can,
the first opponent is
yes. If
G. Ramaswamy said, "Who is your opponent, Mr. G. Ramaswamy?" My lords are my opponent.
No, my lord. Here, my lord, your lordship is always in favor of the law. My lord, your lordship may kindly see the note. It is because it is my bounden duty to point it out. Note of your cause list at item number 8, P3I reflects that the 2 persons of whose promotions are under challenge, none of them have decided to appear.
We can't
That is what, since your lordship said who are the opponents.
They are the opponent, but they are not.
Yes, that is what
the battlefield.
So that is why the relevance of that particular submission of mine. On the other hand, the entire thing has been done by the government and counter
has been filed.
Rejoinder has all.
Because of the interim order, some people are not getting promotion.
Interim order, I have filed my rejoinder.
That is the problem.
If you argue, I will take up the matter. Needs greater details.
Yes, but she may call this matter a week after so that
January.
a week after. January, interim order, such people are retiring. They are not getting promotion.
December, your lordship.
9th of December.
9th, yes.
9th, all right, but you.
My lord, can it be on 17th?
Yes.
7th.
7th.
Oh, yes. Interim order to continue.
Interim order to continue. Let's take off.
Item 53.
Yeah.
Item 53, well, in this case, no counter has been filed.
Counter has been filed.
Not filed, man.
Not filed. Counter will be filed within 3 weeks. Well, in second week of January. Yeah.
Item 54.
Item 54. The rejection order is under challenge. They have not filed counter. But
Mr. G, you file a counter. What do you say? Counter?
My lord, we shall file counter.
despite recommendation in my favor, my lord, they have rejected without compliance with the principles of natural justice.
Recommendation is in your favor?
Yes, my lord.
Second week of
early
difficulty because I have already fixed so many matters and your matter is also fixed. How many days it will take, I don't know. So very interesting points you canvass. Yes.
Right?
The petitioners they agree.
Here also no counter has been filed.
Same order. The date we can. Yes, second week of January. Yes.
Item 56 has been adjourned. Item 57.
Last listed on 9/7/2025, and some documents have been filed by the State Council minor, and we are also directed for filing of the affidavit, counter affidavit.
6 and 7 are deleted. 6 and 8 are deleted.
Yes, they have, and I have filed the amended cost title also. Yes. And they are supposed to file a counter.
Same.
That's why fix a date, my lord, because they are going to appoint, if they will fill up the post, my lord, then my writ application will be in process. But you will also, as an interim measure, you will also directed for subject to result when.
Any action taken?
That is there, my lord, you will also may continue that.
It's there already.
Yes.
More to continue. Okay.
Also fix a date, my lord. Fix it.
Third week of January 26. Yes.
Item 58.
No, filed in this case, but this is a case of transfer and harassment to a lady.
So transfer and harassment of a lady
teacher.
Has been
No counter has not come in this case.
You want to pay counter?
Yes.
I appear for OP6.
You appear for
OP6.
Right. So appear for OP6. Counter may be filed within 3 weeks. Calling the second week of January.
Interim order to continue.
Interim order to continue. Then make it third week of interim order. Yes.
I'm appealing for OP number 5.
You appear for OP5?
Well.
When?
Item 59.
On the previous occasion, notice were issued to the private opposite party number 5 and 6 managers. 6
answered.
On 5, it has been returned answered managers.
He left without any inspection.
Yes, sir. May I take steps on him at his working place, managers? That is a government college at High Court, managers. May I?
Yes, take. Petitioner to take steps in respect of OP number
5, Your Lordship.
OP number 5 by taking the hand summons to him wherever he is working. Okay. If and amongst his standard, copy number 5 to accept the same. Yes.
Grateful.
Registry to facility. Yeah.
Item 60.
Your Lordship, item 60, may I pray for a copy of the counter affidavit?
I have filed already. If my instruction is solved, I will give a copy.
Give a copy.
Just now I didn't have.
Your Lordship, leave to file rejoinder if necessary.
Item 61.
In the meanwhile, rejoinder may be filed by the petitioner to the counter. Yes.
Next. 61.
So, on behalf of Mr. Pandey, let's pray for next week. Any direction?
Third week. Yeah, that's one. Third week. It's a request of public petition. Yeah.
Item 62. Item 62.
Copy not. He is saying petition state council not which received. Third week of available counsel for the petitioner to come and argue. Yeah. Next.
Item 63.
63, my lord.
Yes.
I'm giving that copy. Covered by
yes,
That I will verify that because
my lord.
yes,
You are placed under suspension 22. I am 20.
there are 5 crores of rupees involved in this. Verify that.
My lord,
On
not
9th of December we will have that.
My lord.
Because it appears to be covered by judgment of the apex court.
If it is covered, then I have no objection, my lord.
Yes, sir, you give copy of.
I have already.
It is given me.
A short urgent because I am placed under suspension since 2020, your lordship.
9th of December it is coming.
I'm a mere clerk. 9th December. Obliged.
Item 64.
64.
Covered here. So the RSCP is covered last time. We have to take instructions.
Where is that judgment by which it is covered?
Covered by my lord.
My order.
My lord.
Who appears for the OPs?
I am there.
Mr. G, it appears to be covered.
My lord.
Just verify.
Ashok Kumar Mahapatra. Yes, sir.
That's very bad.
Similar matter has been disposed of by.
Remember, this only thing is this sentence to be completed. Yes.
Item 65.
Number 65. Pursuant to the Lord's direction, I have sought the copy of Mr. Taranam Patnaik, the advocate who is usually appearing for the one of the panel lawyer of the university.
You appear for the university?
Yes, madam.
Your name is not shown here.
Yes, madam.
Yes.
On behalf of Navajan Mahapatra, there is.
Ready?
No, my lord, we'll file counter first.
You want to file counter?
Yes, madam. That's it.
Lordship may kindly fix the date so that it can be.
Second week of January. First of. In the meanwhile, counter if any may be filed after serving copy thereof on the counsel for petitioner. Within 3 weeks.
Obliged.
First, petitioners may file the rejoinder within next 2 weeks.
And within that,
Within next 2 weeks. 3 weeks counter. If you want
2
to file
weeks.
rejoinder within that 2 weeks.
and it will be listed in the week commencing from the second
Second week of in the second week of January. Yeah.
obliged.
Item 66 has been adjourned. Item 67.
66 urgent.
Ajay.
My lord, I am the petitioner. Originally, I was appointed as an headmaster
Yeah.
In this
in
case,
Cordang High School.
sir, fair, my lord. In this case, I am appearing for opinion number 5, my lord. Already filed the counter, my lord. Only short adjournment. Only next week.
No, sir, please.
Next week,
The headmaster is working since 2019.
1 week is.
Till today under this under the junior assistant teachers. So that is this peculiar situation when one headmaster was selected and he was duly appointed and approved during block grant as headmaster, drawn headmaster scale. Then he was reduced to the scale of assistant teacher. Thereafter, one incident happened. One peon threatened him and tortured him in the office. He asked the management, he asked the DO.
What will happen?
The DO called him. But thereafter, what happened? They served a memo to make him the IC. Make him the IC in charge.
Only Monday. Only pre-Monday, man.
Only he wants a 1 week time. That also you have to. No, brother.
But let it be parted. Let it be parted.
Why do you think that Honorable Chief Justice has whispered to you?
No, sir, that I'm not thinking, but I am expecting a good judgment from your good.
We'll have it on 10th of December. Anyway, no bench will be changed by that.
No, sir, no, let it be. I have already argued, no, let it be parted.
Where you have argued?
I have waited for the day to let it be parted or just initiation.
Let us see. Why parted? We'll fully hear you. Yeah.
Item 70.
May I please?
Yes.
The petitioner challenged the terms of the condition of the advertisement, wherein clause 4 stipulated that if more than 5 times of a vacancy post are applicant, then preliminary examination must be passed. They have also conducted 4 number of a category for preliminary examination. But Hindi, Sanskrit and all the...
Who is your opponent?
Who is your Staff Selection Commission? So Lordship, other case, Lordship passed interim order regarding similar matter.
What is the interim order?
And subject to result. And also covered by the judgment. Your Lordship disposed of the matter with a direction to conduct the preliminary examination.
Counsel for the petitioner submits that the coordinate bench of this court by interim order dated 13/6/2025 entered in WP number 16242 of 2025 has granted interim protection to the effect that the selection process shall continue, but short of taking final decision. And therefore, the same interim order needs to be granted in this matter. Mr. G, let selection go on. Let it be subject to outcome of the petition.
This is about national law university.
National law?
No. LTR, leave training reserve, my lord. Teacher, PT teacher. Petition of the PT.
That is interim order by other judge.
The process of selection was yesterday, that matter.
But final decision shall not be taken.
Yes. They have issued Annexure 5, Lordship, the merit list.
Yeah,
With the process of selection go on.
Yes. Same interim order granted to the same interim protection is granted to the petitioner. Call this matter along with WP number 7.
Staff Selection Commission.
Yes.
Oh, sorry. That instruction.
No problem. Sometimes these things happen.
No, I had
in one matter, myself and another senior judge was sitting in Bangalore. At a time, 2 phones ran from the bar, one from the bench. Happens.
My lord, I was
not a great
kept open because of the instruction I was receiving.
No problem. Because I told you to get that information.
Yes.
No issue.
My lord, I had.
Now, what the Tahsildar says?
Tahsildar says that this petitioner had not been given 1/7. He has not deposited the money.
But he said, I wanted to deposit and he did not receive.
Yes, no. That is wrong.
Go and deposit.
No, my lord, yes.
So he will deposit now.
No, it had not been to him 1/7.
My lord, what happened? Tahsildar directly denied.
Why Tahsildar will say no? Why should he say no? When there is a court order.
My lord,
All right, now don't waste time. You go there now. You go and pay.
Yes, madam.
Let it go.
I'm not going there. There is a problem now. Problem is no, my lord. My lord, he denied to receive the money.
Sorry.
My officers are not there.
You go and record the entire thing in your mobile phone.
Yes, my lord.
Show it in the event.
That is in my record also. I have filed the enter certified copy of the court orders, printed out copy of the and representation and all the things. He denied that I will never receive your money.
Money you have not paid.
Yes, I have already approached. I have filed an additional affidavit in my next annexation file.
Ensure that court order is implemented.
My lord, I have told them categorically court's order should not be violated. I had categorically told. I had told my lord, not only to him, to the IIC of that place. I had told them also. Take care of the. No. My lord, that is policy. For compromise. Kindly peruse my affidavit, my lord. Let me. I have already submitted. Complete. Let me, please. My lord, yesterday night there was a meeting sitting both the parties. Cannot be solved the problem. So somebody says that we shall not pay the rent of the tent. Then why is they have already done?
You deposit
nothing done, madam. Director, I deferred, madam.
Yeah, petitioner deposit. How much money he has to deposit?
Revenue that they came the deposit, my lord.
Petitioner to deposit.
Whatever required revenue, they will deposit it.
Sum of rupees. Is it 1 lakh rupees?
No, I do not know, my lord.
How much it is? If you will deposit rupees, you deposit here 2 lakh rupees in the registry. After that calculation, if remaining amount, I will direct you to be returned.
Yes, sir.
Petitioner to deposit a sum of rupees 2 lakh in the registry of
1 lakh, my lord. Jagannath Trust, what? 1 lakh. You are 1 lakh. You are making politics there. No. That is not politics, my lord. Yes. That copy is there. And they denied Tahsildar, denied the High Court order. How do you have to tell? Nobody. Nobody is denying.
Nobody denies that way. It appears you are.
They are also government officers.
They will not do it like that. Petitioner to deposit a sum of rupees 2 lakh in the registry of this court.
1 lakh.
No, 2 lakh. After if it remains, I will give back to you. 2 lakh. By way of an interim measure towards implementation of the order dated
11/2025.
11/11, whereby petition has been disposed of in terms of compromise.
And carry out the Tahsildar will carry out all the order because in present officer is
Tahsildar, on producing a copy of the receipt of such deposit, shall ensure implementation of the order by taking all steps as may be required in the given situation. First of all, parties to the petition to cooperate fully. First off, it is open to the Tahsildar to videograph the entire episode so that there will be no scope for any complaint whatsoever from anyone. First off, a web copy to be acted.
What happened, my lord? What is it 14, my lord? Because today is 14 to 19, your lordship directed. Because their date is 26. Your lordship, 1 day already left, my lord. Your lordship directed and 20. Because otherwise, 2 day already left, my lord. As per your lordship's order. Your lordship kindly see the order, my lord. The celebration of the Mahotsav from 14/11/25 to 19/11/25. Because today is 14. Extension another 20 to 19 to 21. That's 50-50. The people have been forgetting.
Anyway, that's all right. We should not be. By Portia's knife, we cannot cut anything. Yes. You deposit it immediately. So today itself we deposit that.
I will call for they will come and deposit.
On deposit it happens. Otherwise 1 more day will be lost. Yes.
I may be excused, the item number 70 is mentioned and macro is taken up. But the item 70 I am appearing for the Staff Selection Commission regarding that the LTR teachers. This is regarding PET. In that case, no writ application was filed. After a belated stage, they have filed writ application, and by the time the writ application was taken up today, we have already selection is over on 26/9.
What we have said in that?
It's a personal entry model are subject to. So it means our part is over. Selection were recommended. And appointment letter has also been issued by the government.
It will be subject to the writ petition.
Only my submission may be recorded to that and thereafter will be indicated.
We have signed the paper.
No, only fact is that.
I have signed the paper.
No, just now they have
Which
been. Just now.
Last
one. Just now.
But what you reckon?
They have made a mention.
Mention out
That
out of
order of justice.
Yes, I thought my
Coordinate benches has passed this.
Coordinate bench has
Keeping in view that
first.
Lordship said that the interim order
process will go on, but no final.
process is already over, appointment is over, everything is over.
Yeah, where is that? Now I have made the order in his presence and he is not here.
No, my submission may be not.
I know what submission. You have to bring him here now. You when
They have
you
left
come, we cannot-
Number दे दो जी
on mention.
This matter tomorrow.
Yes.
Monday. You tell.
Yes.
I'm
One
giving.
second. Right now. If already selection is over and appointment orders are issued,
Counseling is over.
come on. There, the same will be examined at an appropriate period. But this also order will remain the above one. So this will
In addition.
as submitted by learned panel council,
So from standing council, staff selection commission.
standing council appearing for the
Staff selection commission.
staff selection. Okay. Because already appointment order also.
Now, upon the government is to issue. Counseling is over 7-11. So by this time, counseling is over, everything is over.
That will suffice, my lord, because on their part it has been clarified.
So from our part, our job is over.
Yes.